when I did for many years. Martin Luther King Day is, of course, a federal holiday, but it's not a holiday for Virginia as a state law, or at least it wasn't at the time.
Okay.
And the state legislature in Virginia only meets for like 4 months, and they start the Monday before Martin Luther King Day. So as a result of that, it was very common for people to go down on Martin Luther King Day, because a lot of people have the day off, to go to protest, and a lot of people did, and I did every year to go to protest. I went to the seat of government, and I ran up and down the halls of the state legislatures to speak to my various representatives and make my voices heard, and then went outside to express my displeasure about things. So I don't think the fact that I went to the seat of my government and expressed my displeasure indicated intent other than to make my voice heard and to advocate for my causes.
What were you protesting for?
In that particular case, I was protesting for broader gun rights, because I'm a Second Amendment guy.
Mm-hmm. Do you think that's certification process?
Well, I don't see how the subject matter of the speech turns the difference, because the First Amendment protects all subject matter.
Well, hold on, that's not true. Wait, that's not true. First Amendment absolutely does not protect all types of protests or types of speech or whatever, right?
As to topics of discussion.
Morning, good night, right? Good evening. So, there we go.
You're thinking, for example, like
currently listen to uncivil law because I have the day off today.
As exceptions to the First Amendment, then yes, but it doesn't restrict as to subjects or topics. So I can talk about anything. I might be.
The food was okay.
About how I go about it, but the topic.
It didn't mute the pain.
Any subject in which
I don't even know why. I don't even know why. It's funny because it's funny because of how salty it was last night. It's stupid because I told myself all year to not get my hopes up, and I really didn't, especially because they kept on losing to above 500 teams, and so I didn't keep my hopes up at all. And I told them, don't talk to me until we get to the NFC Championships game. And then even though I tried my best not to keep my hopes up, I'm still salty about last night. It's so stupid. They do it again. They do it every year. It is what it is. Trevor, I have no idea. I don't know what the hell's going on over there. I did bother watching the game, as you guys know. I barely watched. I watched the first quarter, and that's about it. As soon as what was going on.
If you can name one, like what?
Alpha, yeah, I'm listening to Kurt talk with Destiny. Kurt from Uncivil Law talk with Destiny about January 6th.
Why can I not go to the legislature and demand that they take attention of issue X? Is there any issue X that I can't demand that they take notice of?
No, I can imagine you.
Nice, Edward.
Yeah, so there's no restriction on subject matter. That's my point.
I would definitely agree with that. I think that if the January 6th protests would have just been protests outside of the
Gamer for Life, you might be right. I think that Dak can't handle the pressure. I think that's probably it. I think Mark McCarthy is also a problem, but I'm going to say straight up that it's probably a Dak Prescott simply can't handle the spotlight.
Outside of the Capitol building, and no trespassing or violence would have occurred. I think that'd be comparable here, but that did happen. And once crimes start to get committed, I think then we have to go back and we have to look at, I think that we can start to be more critical of the, I guess, the subject of the protests, right?
I don't think that quite makes sense. You know, if my group that had gone down there to protest for gun rights had spontaneously become violent, which fortunately never happened, but if it had, then I don't think that changes the intention for why we're down there in the first place, or our ability to use sharp rhetoric. So as we're out there, protesting for our rights, I don't think the fact that violence occurs somehow goes backwards in time to change our underlying intent. If we'd gone down there for the purpose of creating disruption, if we'd gone down there for the purpose of engaging in physical violence, if we'd gone there with the intent of physical or other sort of desire, then I think the intent is what carries through, not the actions that emerge. The fact that actions occurred turns it into a riot, not an insurrection.
Okay, let me hypothesize two different speeches. Okay.
Sure. Okay, go ahead.
Let's say that. Let's say here's some. We'll say here's some.
Morning.
Facts, okay. We're gonna say we're investigating a situation and we don't know the initial speeches. Okay. Here are some facts we're given. Okay. A group of 100 people. A group of 100 people march to a state building. Okay. We're gonna say they're all pro Second Amendment rights. Let's say that they all, during the protest, end up entering the building. Let's say that violence ensues between protesters and police, and let's say by the end of it,
Giselle, Kurt is speaking to Destiny, who is a fairly popular liberal political streamer. I've been following him since like 2022. I think he's probably the most grounded liberal. I probably agree on a lot of his takes, and he's caused me to consider a lot of different positions I used to have. It's the same Destiny where his wife left him for her Saibu. Yeah, that Destiny.
7 protesters and 1 police officer are killed, and then eventually everybody's cleared out. Okay. So here, so our facts are: we got 100 people march to a state building. They're all pro Second Amendment rights. During the riot, they're there to like protest for Second Amendment rights. Let's say that I'm going to add that here. Okay. Well, no, I won't add that yet. I'm sorry. I'll do the speeches. Okay. They all during the riot end up entering the building. Violence ensues between protesters and police. 7 protesters, 1 police officer are killed. Okay. Those are 5 facts, right?
Sure.
Okay. Let's say now that we get video footage of the let's say that we get video footage of the leader of the rally speaking prior to the people leaving to go and march to the state building. Okay. Let's say that in one world, let's say that a speaker is like, today in our state legislature, they're gonna ban Sonic stocks. Okay. We believe that it is our Second Amendment right to have these stocks. This is bullshit. We are going to go and make our voices heard. Everybody pick up a sign. We're going to march outside, fuck these guys, blah, blah, blah. Okay. That's speech 1. Okay. Sure. Let's say that, in another world, we get insight into what's going on. And let's say speech 2 is today, there's a new governor who's going to be sworn in, and he is opposed to the Second Amendment. They're going to steal our firearms. The government is coming after our firearms. We're going to lose our Second Amendment rights. Okay. We will not stand for this guy to be in government. Okay. Today's when they swear him in. We're going to go down. We're going to protest like hell. We will not accept this guy as our new governor. Okay. Let's say that's the second speech.
Okay.
When you look at the 2 of these, and then both of them end up in violence, and both of them end up with a couple people killed, and they both end up delaying the certification process. In that world, wouldn't we say that, well, for the first speech, it kind of seems like, they protested, they were trying to make their voice heard, shit got rowdy, whatever. But for the second one, man, it really seems like their goal was to try to actually obstruct the certification or the appointment or whatever, not appointment, the election or whatever the fuck of the new governor. And they actually kind of succeeded in that end. At least they delayed it. Would you not weigh these things differently based on the rhetoric and everything going into it?
Well, if what you're alluding to is incitement, which seems to be what you're discussing, then I would go to Brandenburg as the test for incitement. And because it's a well-honed First Amendment law. So speech is not protected under Brandenburg.
Well, hold on real quick. So I'm not actually, I'm not even interested in the crime of incitement. Which I don't.
Yeah, he's not even talking.
Incitement.
He's not talking about the crime.
I'm just saying for the.
I think what Destiny's trying to ask Kurt is not about whether or not what his language, what Trump's or the speaker's language was in fact criminal incitement. What he's trying to get at is whether or not what that speaker's intent was to happen, whether the intent of the violence that ensued is gleaned from his words.
in terms of like an insurrection, or in terms of like what the goal is and what the outcome was, would we not weigh the speeches and the rhetoric and everything going into these? Would we not consider the outcomes different based on the rhetoric and everything going in?
I understand where you're coming from, and I don't think it's wholly illogical. But my sort of natural inclination is to try to find, as best I can, a bright line between what's legal and what's illegal, because I don't really want to be squishy when it comes to the First Amendment.
Thank you, Akira, for the $4.99.
First Amendment view, because I believe that people should be allowed to speak their mind, and they should be allowed to disagree with each other, including rudely and whatever else. And for that matter, I don't think there should be laws against hate speech. I don't think you could even define what hate speech is, and there are no laws against hate speech as such because it's undefinable. So I think the reason I went to Brandenburg is because I'm looking for a legal test that separates the legal from the illegal. So while I agree that there, in your hypothetical, the speech that is more inflammatory is certainly closer to the improper line, I don't think this should be a balancing test, or, you know, if it's more inflammatory, then we don't need as, I don't think it should be balancing, which I think you're tending to suggest. You know, if it's more inflammatory, then we don't need as much, or if it's less inflammatory, we need more. I think we should try to figure out from a First Amendment point of view what speech is protected and what's not. And as long as it's protected, as long as it's on the right line, then it can be as inflammatory as the person wants it to be, because it's fundamentally protected First Amendment speech.
But it's not about. But I think, Kurt, again, and I haven't seen this before. I'm listening to this for the first time. I think Destiny, and where I would be coming from, is we're not talking about whether or not we want to criminally charge the speaker in this hypothetical. We're only trying to glean what the speaker's intent was, and whether or not they wanted like an insurrection to occur as a result of the speech. We're not in the realm of trying to criminally charge him for the speech itself.
Okay, well, is there anything that would qualify for you as an insurrection that doesn't involve incitement to riot?
Bob Brown, you think January 6th? Yes, to trying to get a mens rea of the speaker, because they're trying to draw a distinct. What Destiny's trying to draw this distinction between the speaker's language is like, if the speaker says this, which on to an outside observer seems fairly measured, and fairly, you know, not as inflammatory as B speech, but in this hypothetical, A speech and B speech happens, but the result is the same. People end up getting violent. They go to the Capitol. They get violent. And they disrupt a certification process for this person because of their Second Amendment. They're afraid that their Second Amendment rights are going to be violated. What he's trying to get Kurt to agree to, or try to get Kurt to engage with, is that speech A, which was less, which we would classify as less inflammatory, could suggest that the speaker did not actually intend for that subsequent violence to ensue, and did not actually intend for the results that occurred at the Capitol. Whereas with speech B, which is a lot more inflammatory, even if it's not criminal incitement, can glean that you can draw an inference that the intention of speaker B was to get that crowd to be violent, and disrupt the process.
Oh, sure. Yeah. You wouldn't necessarily need speech at all if you could show the coordination in advance. You don't need the speech to be the prompt. It could be that a group of terrorists somewhere in some.
Why would you need, what would the coordination look like? And then I'll just, so that it doesn't, I'm not trying to trap you, because whatever coordination you give here, I'm going to ask why. My next question is going to be, why is Donald Trump sending 100,000 people to the Capitol to protest the certification? How is that not a level of coordination? That's what I'm going to ask next. So tell me what the,
there's coordination for a lawful purpose and coordination for an unlawful purpose. I mean, for example, you and I have coordinated in order to have this talk. So the fact we coordinated didn't make it illegal. So the coordination needs to be unlawful. That's like the difference between conspiracy and just, going out for a...
Are they trying to say that a lack of saying something in order to stop violence was tantamount to inciting violence? No. I don't think we're not even there yet, Gary.
a meal together or something. So I think in the example of a non-speech, you'd be looking towards, a person who gets together, for lack of a better description, a group of militia people who go together with the affected intent to engage in violent disruption, which I think is true for the Proud Boys in December 6th, Oath Keepers perhaps as well. And you could also find other groups that are comparable in other situations. So
sure, but what about the fact that the majority of the people that were indicted, I think, is like trespassing and committing violence? I don't even think the majority of them were Proud Boys or Oath Keepers.
No, that's correct, and I don't think those people engaged in insurrection. I think they engaged in a riot, which manifested in trespassing and.
So if those people thought that they were going to the Capitol and they were fighting on behalf of Donald Trump, who was going to lose the presidency because we agree there was a rigged election, and they were chanting 1776, which is when we fought for our own insurrection and rebellion against the British, and they effected violence to achieve some end of delaying the certification of the vote, which they did. I don't understand what possible element we're missing here to make this constitute an insurrection. We have everything except for the fact that it failed.
Well, I'm not sure how much you think the situations are comparable or not, but wait,
before because everybody likes to make comparisons and jump to BLM and other stuff. I'm just, in this particular thing, what are we missing for this to be an insurrection? I feel like every single element is easily met. I don't know what we're missing.
I don't.
What part of an insurrection do you think hasn't been satisfied?
All right, okay, well, I'll have to save this for another day. I mean, I feel like there's a lot. I'm not surprised that there's a lot of back and forth in the chat. I feel like one of these days I actually do want to do a deep dive into January 6th. I remember people saying, I think actually I privated that live stream when I was live streaming the day of and seeing what was happening. I think I privated, that's why people couldn't see it. But I think I want to talk about January 6th because I feel like a lot of people to this day still believe in a lot of bullshit relating to that day, including people who think that it was it was complete. I mean, I heard people keep on saying that it's a Fedsurrection, which is cringe as all hell. But I do want to talk about it. But I'll save that for later. Let's go back to Miss Reed. All right, let's go back to Miss Reed. All right. Look at the sentences for January 6th protesters. Nothing but the people who burned Minneapolis to the ground. Okay, so yeah, okay, Bob, we're gonna have to talk about that, but all right. I don't think Destiny's smoking Kurt or Kirk is smoking Destiny. I think we're halfway through. I'm halfway through this video, and they both seem to be engaging each other pretty well. But I don't think anybody's owning anybody here. And honestly, I think both parties are being pretty good faith in this, which is more than I could say with other people who try to tell Destiny that it was all a Fed plant. Anyway, Karen Reed hearings. I'm trying to think of which is the most recent. The last one we saw was like 3 months. From 3 months ago, right? Maybe this one from I think we did see this, but I think I want to start from the beginning now that I have a little bit more more detail in the background.
Give your attendance, remain seated.
Your Honor, this is
And this is what dated January 5th. Oh gosh, where's that link? Well, I think I thought I had the Dropbox link saved. Oh, here we go. Superior Court. And we are this is January 4th, so we're close to it. Oh, wait, this is the DNA one. Right? And subpoena motion. Okay.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor.
Commonwealth.
Good morning, Ms. McLaughlin.
Your Honor, Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti on behalf of Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right.
Could I just have, Mr. Reddington, could you identify yourself for the record?
Sure. Kevin Reddington, I represent Jennifer McCabe.
Good morning, Mr. Reddington. I appreciate you joining us today. I know that you're out of the country. Thank you. All right. So we have 4 sets of motions. The first one that I would like to address.
Free my boy Tibbsy.
What was that, Jim?
I don't know what that was.
I think it was somebody on Zoom.
Yeah, it was. Is that I thought I heard somebody say "free my boy" something. Well, obviously, this is from 9 days ago, so Turtle Boy has since been arrested.
So it only could have been maybe. I think we're all set.
All right. So the first motion I'd like to deal with is the defendant's motion for Rule 17 records directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
Free my boy Billy Tibbetts. Free Billy in the trap.
Kevin,
Free Billy and what?
just be either mute or watch us.
Jim, that's not me. It's somebody else is saying free my boy Billy Tibbetts. It's not me.
Okay.
Who the hell is Billy?
Go ahead,
Who the hell is Billy
Mr.
Tibbetts?
Jackson.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom.
A hockey player?
If this keeps up. We will have to cancel Zoom for everybody if this keeps up.
I think I got that person, but
Fuck off, Beverly.
maybe I didn't.
Billy Tibbetts served 39 months in prison. The sentence on assault battery was 30 months, but it was served concurrently with a previously suspended sentence of statutory rape. As a result of the convictions, Tibbetts had to register as a sex offender and could not play games in Canada. That reminds me of that South Park episode where everybody's like, free hat, free hat, free hat, free hat. You realize that, like, he was wrongfully convicted of murdering 23 babies. I was like, what the fuck?
Go ahead, Mr. Jackson.
Your Honor, I want to try to save some judicial resources. If the court is inclined, given the Commonwealth's position that they are in agreement with us to issue the summonses, I'll just submit on the papers and be done.
I have third parties that need to be heard.
If the court wishes, I'm happy to address the third party concerns once they are heard.
No, I'll hear you now.
In terms of the papers that were filed, and my understanding is Mr. Reddington joined on Ms. McCabe's behalf with Elizabeth Proctor's motion and her position filed by her counsel. It basically comes down to a singular issue, and that is one of privacy. They don't have standing to argue Lampron. They're not parties to this action. It appears the Commonwealth, who is the party to the action, has agreed that Lampron, the elements of Lampron have been met with our request insofar as it is concerned, specifically an address to Michael Proctor, Trooper Michael Proctor, and his communications with Jennifer McCabe, Elizabeth Proctor's communications with Jennifer McCabe, Jennifer McCabe's communications, counter-communications with Elizabeth Proctor, and Michael Proctor's communications with Brian Albert and Nicole Albert. I'll address the issues that counsel raised in his moving papers on behalf of Elizabeth Proctor, because that's the only writing that I have to go on at this point. He basically argued that there are false statements made about Michael Proctor's relationship with some of these other parties.
Okay, so right again, like they're now not re-engaging, but reiterating this relationship between Proctor and Trooper Proctor and the Albert family.
Since the very beginning, and that brings up the fundamental issue, Your Honor, of what is that relationship and what's the nature of the relationship, and why do we believe that that relationship establishes extrinsic evidence of bias and an inability to be neutral. From the very beginning of this case, we have questioned the neutrality and the bias of Michael Proctor and certain other government witnesses. Based on overwhelming facts that we've learned, overwhelming facts that establish that both this investigator and this investigation are compromised. That's why we...
Free Tibbetts.
Do you have that, Tori? Okay. Go ahead.
Thank you.
I'm not even hungover at all.
For the communications that the Commonwealth has now agreed with. Our request is nothing short of critical to our defense, obviously, and it's based on Ms. Reed's constitutional right, as established in Davis versus Alaska, the U.S. Supreme Court constitutional right, that's recognized as the right to attack the credibility of any government witness, be they a government witness on behalf of the police and the investigation, or any other government witness.
Is Elizabeth Proctor a government witness?
She is not, but Jennifer McCabe is. And the communications that we're interested in are the communications that are concomitant between Elizabeth Proctor and Jennifer McCabe. We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor and these third-party culprits that have been implicated in this case that we've brought to the court's attention, the Alberts and the McCabes. That's the relationship, and that's the foundation of our request. This is so important that I'll bring it back to the court's attention, and the court knows this, that even the sitting DA, the elected DA, decided to weigh in on this issue of the relationship between the Proctors and the McCabes and or the Alberts. And he said there's no such relationship, zero. This doesn't exist. As a matter of fact, the word that he used was, it's a lie. Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabes or the Proctors and the Alberts is a lie. His words. So the DA himself has put Trooper Proctor's neutrality at issue, And he did it in the most public way possible, and I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all done. He didn't address the court, he didn't address the Commonwealth, he is the Commonwealth, he didn't address us, the defense. What he did do is he addressed the public and the potential jurors, and that was by design.
Oh.
So he calls the evidence that we've procured and that we've presented to the court as
Oh, really?
lies. Well, let's look at those lies for...
Actually, you know what? Let's... Alpha, let's actually look at the DA statements. Is it Michael? What was it? Michael, Morrissey. August 25th, 2023. Michael Morrissey statement. There we go.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney.
Norfolk.
Witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen.
Gamer for life. Isn't this considered tainting the jury pool? I mean, no more than I mean, if this is tainting the jury pool, then so is the billboards that Turtle Boy paid out, the various protests that are outside of the courtroom, Turtle Boy's blog, and podcasts and YouTube videos. I mean, I'm looking at this video right now. This is uploaded from CBS Boston, and it's got less than 3,000 views. I'm sure that the local news channel probably uploaded snippets of the video, but I mean,
for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
okay, that was the DA speech.
Give your attendance, may be seated.
Specifically, an address to Michael Proctor, Trooper Michael Proctor, and his.
Do you have that, Tori?
And this investigation are compromised. That's why the U.S. Supreme Court constitutional right that's recognized as the right to attack the credibility of any government witness, be they a government witness on behalf of the police and the investigation, or
which is true.
The government witness.
Is Elizabeth Proctor a government witness?
She is not, but Jennifer McCabe is. And the communications that we're interested in are the communications that are concomitant between Elizabeth Proctor and Jennifer McCabe. We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor and these third-party culprits that have been implicated in this case that we've brought to the court's attention, the Alberts and the McCabes. That's the relationship and that's the foundation of our request. This is so important that I'll bring it back to the court's attention, and the court knows this, that even the sitting DA, the elected DA, decided to weigh in on this issue of the relationship between the Proctors and the McCabes and or the Alberts. And he said there's no such relationship, zero. This doesn't exist. As a matter of fact, the word that he used was, it's a lie. Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabes or the Proctors and the Alberts is a lie. His words. So the DA himself has put Trooper Proctor's neutrality at issue, and he did it in the most public way possible, and I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all done. He didn't address the court, he didn't address the Commonwealth, he is the Commonwealth, he didn't address us, the defense. What he did do is he addressed the public and the potential jurors. and that was by design. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, the person by the name of Colin Albert, pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie, it's a photograph. And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together, they're in a wedding together, in the wedding party. There's a third photograph.
And when was that? When was
this was from this is from a decade ago. And so you're saying this is not yet exhaustive examples. And we have I'm reading the defense's motion here. I'm saying 1, 2, 3, 4, 5, 6, 5 photos. One from 2016, three from the wedding in 2012. A photo from 2017 and a Facebook post by the mom referring to the by Proctor's mom referring to Chris, Julian, Colin, Albert as her second family. Okay.
When was that?
2012. So this relationship, as the court just noted, and I was about to get to in a second, is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. So when counsel for Elizabeth Proctor suggests, oh no, these relationships, you can't believe any of this stuff, just because someone happens to be at the same event does not thereby establish a relationship. They weren't just at the same event. They're in a wedding party together. They're standing on the dance floor, side by side, shoulder to shoulder, Trooper Proctor and Colin Albert. And then we see a photograph of all of them seated at the same dining room table. They shared a meal together. This is socializing. These are interpersonal relationships, and they can't change that. Trooper Proctor was seated at the same table, having dinner with Colin Albert, Chris Albert, and Chris Albert's wife, Julie. Then there's the Facebook post, and I will leave it at this. I'm not going to go through the entirety of my motion, but I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family. So one might actually ask, Mr. Morrissey, who's actually lying in this case? Is it us? We just...
Yeah, like he's saying that, oh my God, they were in the wedding party. Where was it? The Albert family was in Trooper Proctor's sister's wedding party. But from what the state says, the state has said before, or somebody said before, that Colin at the time was like 5 or like 10 years old. Like 10 years old, and was the ring bearer. I feel like if you're going to say that they were in the party, in the wedding party, my presumption would be that, Trooper Proctor was among the groomsmen, or that Trooper Proctor's wife was a bridesmaid. Having Colin Albert be like, or the Alberts being like a groomsman or bridesmaid, not just having the kid be the ring bearer. I mean, sorry. The familial relationship. I mean, I'm not going to outright dismiss it. I mean, being being a part of a wedding at least implies some level of association. But I feel like I need more than that. That Trooper Proctor, or excuse me, that the Alberts were at Proctor's sister's wedding a decade ago. I feel like I need a bit more to establish enough of a connection to warrant Proctor being willing to cover up a potential crime against the a crime that the Alberts committed. I feel like I need to see a bit more of than just appearing at a wedding 10 years ago and then a birthday party 5 years ago. Right, the Michael Proctor's sister. Right, that's what I'm saying. Like the degrees of separation is such that I feel like I need more. I'm going to need more than just the wedding to say like, oh, they are so connected. They're so intertwined that they are willing to cover up a potential murder committed by the Alberts.
Presented the court with factual information that was procured off of social media that it's unassailable. It can't.
Because remember, this is what the defense is arguing. The defense is arguing that the Alberts, either Brian or Colin, I don't know who at this time, got into a fight with John O'Keefe. I don't know what the motive is that the defense has raised yet, and left him for dead in the yard next in their front yard, like or like on the far corner of their property. They left him for dead, and then Proctor. They say like that Albert, like I guess part of their case is that they're going to say that they can find evidence that Albert pulled strings to get Proctor on the case, knowing that Proctor would cover for them and taint the crime scene in their favor, and to frame Karen Reed for it. Because I think that's part of the defense's strategy is like they want Brian Albert's information, they want his phone records and whatnot, to try and find any kind of phone call that was made to Proctor to get him assigned to the case as the investigator, knowing that Proctor will go to bat for them because of this close personal relationship that they've had for a decade.
Cannot be assailed. And the Proctors have known these people for, as the court just mentioned, by asking for that date, for more than a decade. They've socialized with him, and his family considers their family to be so close and interconnected that they are deemed a second family to the Proctors. And who exactly are members?
Right, but the problem that the defense counsel is saying, and I think the defense counsel is being a bit disingenuous here, is that Trooper Proctor's mother in that Facebook post was referring to Chris, Julie, and Albert as her second family, not the entirety of the Albert family. And they don't even according to the post, Proctor's mother doesn't even mention Brian Albert.
Of this Albert family and or McCabe family, let's look at those members. Brian Albert, Nicole Albert, who is Jennifer McCabe's sister, Brian Albert Jr., Brian and Nicole's son, Caitlin Albert, Brian and Nicole's daughter, Jennifer McCabe, Nicole Albert's sister, Matt McCabe, Brian Albert's brother-in-law, Chris Albert, Brian Albert's brother, Julie Albert, Brian Albert's sister-in-law, and Colin Albert, Chris and Julie Albert's son. The McCabes and Alberts ostensibly are one family. They socialize within the same social circle and the same familial circle, and that is who the Proctors have proclaimed to be their second family. And if that—
Not the yeah, he keeps on saying the Proctors. It was Proctor's mom. Trooper Proctor never made this comment beforehand saying that the Albert family was their second family.
That weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting? Because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting. No, he never disclosed it. We found out about this because a concerned citizen happened to photograph Jennifer McCabe's car parked outside Michael and Elizabeth Proctor's personal residence in the evening after hours. And the best that counsel for
Bob Brown, curious, does anyone in this chat think Karen is innocent? I don't know. I think at this point I have strong reservations as to whether there's sufficient evidence to find her guilty of murder. I think their initial charges for her were which was like manslaughter, was probably appropriate. I don't know why they upgraded for second-degree murder. Second-degree murder in Massachusetts is a deliberate killing of another without malice aforethought. Or excuse me, no, it was a deliberate killing with malice. But without like deliberative planning ahead. A first-degree murder is usually is premeditated murder. Second degree in a lot of states is intentional murder, but without premeditation, meaning that you within a very short period of time, you decided, you know what, I'm killing this motherfucker. I don't know if that's the case. I feel like given the state of the relationship based on Karen Reed's phone and Mr. O'Keefe's phone, that there's issues going on in the relationship. Given the fact that they both arrived at the bar at separate times, noted that they were which suggests to me that obviously the relationship was not very good. There's the evidence that O'Keefe wanted out, Karen Reed didn't, and then she got shithouse. There's probably something going on between the two of them in the car ride, and then maybe in her drunken state, probably hit her. And probably it was so drunk she probably could she may not it may be believable that she may not even remembered it happening, which corroborates with what she was saying allegedly with what she allegedly said to Jennifer McCabe when they were trying to find him. So that's where I kind of am right now, that they have sufficient evidence to do for manslaughter, certainly not really murder. But that's where I
am. Elizabeth Proctor can muster in terms of an argument is to say, well, you know what, Your Honor, maybe he wasn't home. Maybe. Or maybe not. The suspicious part is Trooper Proctor isn't saying. And there's nothing in Elizabeth Proctor's motion to suggest that he wasn't.
No, Kate, you say I do not see the murder too. I think of Matt Solid is a slam dunk. And you said no. The best guess is they upgraded a murder because she knew she hit him and did not get help for him. That's what it looks like. I think that's what they're trying to argue whenever they make a statement on the case, that they highlight that the Lexus's detection system was working fine, and the cameras were working fine. So they're arguing that at the time, if she, by virtue of her hearing, most likely hearing the Lexus detection system, that something's there, and yet she still probably hit him, and then leaving. That's where they're trying to glean the intent from in terms of murder. So that's what I'm getting guessing here. I assume that's what you're referring to in terms of the evidence available. That the fact that the Lexus's detection system was working, she knew or should have known that she hit something, or someone, and then just left.
Certainly his car was there. Elizabeth Proctor's car was there, and Jennifer McCabe's car was there. Was Trooper Proctor home? I guess I would answer that by asking the question, does it matter if Trooper Proctor was home? They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem. And it shows more than a professional connection. It shows a personal connection. And according to the Proctor family's own counsel, Elizabeth Proctor's counsel, the subject matter of that meeting was commiserating about this case. They weren't talking about sports. They weren't talking about the weather. They were meeting about this case. So how does that not show a bias, and how does that not implicate Karen Reed's constitutional rights to this information? And to this day, the Commonwealth has yet to concede what obviously is now sort of front page news, that there is in fact a personal relationship between the Proctors and their second family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession. On October 3rd, 2022, Mr. Lally made a couple of points, eloquent points, in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate relationship would look like if one existed, what a conflict of interest would look like if one existed. And he said, quote, Michael Proctor has been fully vetted, end quote. He said there's no conflict of interest here because it's not like, quote, these people are socializing together, end quote. He said it's not like, quote, these people know each other, end quote. And he went on to say it's not like, quote, these are people that Trooper Proctor has been over to their home, end quote. The Commonwealth said that because these facts would surely illustrate a conflict of interest. They would surely illustrate an undeniable bias. And those comments, I would suggest, have not aged well. And I would wonder at this point if the Commonwealth hasn't adjusted its stance, which is why the Commonwealth is now conceding that we're entitled to these communications.
Ari, don't you think what the defense is doing now is shifting the burden to themselves, where now they have to prove that it was other people responsible and not Karen? Well, no, I don't think they're just trying to shift the burden. They're trying to raise reasonable doubt. The whole strategy that they're having is they're trying to raise reasonable doubt that somebody else could have committed the murder and not Karen Reed. And it is the state's burden to show that it could only have been Karen Reed who committed the murder. That's on the state's end, but the defense is not trying to prove that the Alberts killed. The defense is not trying to prove that the Alberts killed O'Keefe and Trooper Proctor helped cover it up. The defense is simply trying to raise reasonable doubt that Karen Reed, committed the crime, or that somebody else, it could be reasonably concluded that somebody else killed O'Keefe and not Karen Reed.
And that turns.
They're trying to put that
of asking
into the minds of the jury with this strategy.
Honestly, investigate this case as the lead investigator, and also investigate the Albert McCabe involvement in this case, with this history of an interpersonal relationship and allegiance to those very people, the very third-party culprits, the very people who should be suspects in John O'Keefe's murder. And the answer is he cannot. And since the authorities, including Michael Morrissey, apparently have vouched for Trooper Proctor, my client, our client, Ms. Reed, is entitled to question and to test that voucher, and that's what we're seeking to do with the communications between Elizabeth Proctor and Jennifer McCabe. And insofar as that request is concerned, it's unquestionable that there are privacy interests at play, but I would suggest the following: that the constitutional due process rights of any criminal defendant in any criminal case hold a paramount significance because they form the very backbone of the justice system that this court presides over. And protecting those rights, such as the right to a fair trial, such as Ms. Reed's right to the presumption of innocence, that ensures an equitable trial and an equitable process. And while privacy rights of Elizabeth Proctor, a third-party witness, are obviously an element of concern and consideration for the court, they must yield to the imperative of a fair trial. And that imperative means Ms. Reed's ability to confront and properly cross-examine all witnesses, including Jennifer McCabe, including attacking the credibility of government witnesses, including Jennifer McCabe, based on bias, and that is fundamental to our justice system. So striking this balance ultimately upholds the integrity of the very system that this court is making sure exists and continues throughout the process of this trial. Elizabeth Proctor's privacy rights, while they exist, especially in light of the narrow focus of our request, are vastly outweighed by our client's right to a fair trial. And with that, Your Honor, I'll submit.
All right, thank you. Mr. Lally, are we going to hear first from counsel for Ms. Proctor, counsel for Ms.
Yeah, so I'm reading this on page 6 of the defense's motion, where they're talking about the meeting on September 26, 2023. Rather than discipline Trooper Proctor for further undermining public confidence in these proceedings, the Massachusetts State Police undertook an investigation to identify the individuals responsible for outing this incredibly unethical and unprofessional conduct engaged in by Trooper Proctor. On September 26, 2023, Lieutenant John Fanning of the Massachusetts State Police conducted a CJIS audit and confirmed that someone in law enforcement outside of MSP, Massachusetts State Police, had queried the license plates of the three vehicles observed outside the Proctor residence on September 25th, 2023, which came back to a white Jeep registered to Matthew McCabe, a vehicle registered to Michael Proctor, and a vehicle registered to Michael Proctor's wife, Elizabeth Proctor. And this is underlined. Jennifer McCabe subsequently admitted to Detective Lieutenant Brian Tully that she went to Trooper Proctor's personal residence for what she described as a social visit with Trooper Proctor's wife, Elizabeth Proctor, on September 25th, 2023. Jennifer McCabe gave a self-serving 3-sentence statement claiming she was visiting Elizabeth Proctor because they have bonded over this case, which alone is shocking and wildly inappropriate. I don't know why it would be. They're witnesses, and from my understanding, the reason why they made, which obviously the defense attorney did not state in this motion, is that the reason why they were bonding was because they were getting equal levels of harassment from, I assume, is Turtle Boy and his followers. However, photographs from that night clearly show Trooper Proctor was home and his vehicle was parked in the driveway. It's worth noting that on October 3rd, 2023, Assistant District Attorney Lawley represented to this court that the Commonwealth fully vetted Trooper Proctor and does not believe there's sufficient conflict of interest because these are not people that socialize together. These are not people that know each other. These are not people that Trooper Proctor has been over to their home. Transcript of October 3rd, 2023, hearing at page 23-24. This representation by the Commonwealth has not aged well. Indeed, even the ADA Lawley recognized it would be completely inappropriate and present a debilitating conflict of interest should it be the case that Trooper Proctor and his wife socialized with Jennifer Proctor and, for instance, spent time at another's home. Except that is exactly what the facts have borne out here. Well, my thing is like whether or not I feel like the timing should matter. If it was the case that Jennifer McCabe and Trooper Proctor and Trooper Proctor's wife were socializing and going into each other's houses before this case, I think that could raise some issues. Absolutely. Actually, it would raise some serious issues. The problem is like my understanding when this meeting happened was in the midst of this trial, in the midst of this case. And again, the defense is not putting in the outside, the greater context that Turtle Boy and his group have been harassing Proctor's wife and McCabe family from almost since day one. So yeah, I could see that. I could see them coming together for that.
Ms. McCabe, I got an appearance this morning of counsel for the troopers as well. Counsel for the troopers going to address us.
No, Your Honor, that's in reference to another motion.
Okay, so I will hear counsel for Ms. Proctor.
Thank you, Your Honor. Good morning.
Good morning.
Andrew Kettlewell for Elizabeth Proctor.
Good morning, Mr. Kettlewell.
So, this is not a balancing test between the defendant's right to a fair trial, which is obviously constitutionally protected and paramount to our system, and Elizabeth Proctor's privacy rights. This is a request to bring evidence before this court for the purpose of trial under the mechanism of Rule 17 that is not within the framework of Rule 17. And I'm sure the court has had the opportunity to review our papers. Our sole basis of an objection is not Ms. Proctor's privacy rights. That is obviously a paramount concern to any third party, and the interest in not being harassed or brought into a criminal matter or a civil matter that individual has no involvement in is obviously of interest to anyone. But as it relates to the standard here, the question is whether the defendant's request satisfies the 4 prongs of Lampron and the basis of Rule 17. And the defendant's request, I would submit to the court, fails on 3 of those 4 prongs. And I'm not going to belabor the facts underlying this whole situation. My brother laid out his case. That is laid out quite clearly in his affidavit as well. What I would say about the facts is, with regard to the first prong of admissibility and relevance, while hearsay that is reliable is certainly sufficient as a basis for a subpoena to issue, hearsay which is not a basis for a subpoena to issue. And in this case, my brother's affidavit essentially amounts to a large collection of conjecture and allegations which are not supported. With regard to the motion and the opposition that I filed, I appended an affidavit that lays out the basis for why
Noted, Deadpool.
Assert what I assert in my affidavit, and that's essentially conversations with individuals who have personal knowledge of where Michael.
No, my brother. He's referring to opposing counsel. That's I've learned that's an etiquette thing. To refer to my brother, my sister, in terms of opposing counsel's motion.
Michael Proctor was, on the night of September 25th, 2023, individuals who have personal knowledge of the connections between, as my brother says, these 2 families, and who have personal knowledge relating to the actual photograph that my brother didn't mention in Exhibit C of his affidavit of Michael Proctor with two children who are still minors, who are not children of Jennifer McCabe. Essentially, the relationship between these two, quote, families is a distant connection that involves 5 separate steps of relationships between, I guess I'll call them relatives. Mr. Proctor's sister has a friend whose sister is married into the Albert family. And that's Chris Albert, not Brian Albert. And so what brought these different families to a wedding in 2012 was the fact that Mr. Proctor's sister, or Elizabeth Proctor's sister-in-law, was getting married, had her friend at her wedding, and her friend's sister and her family also wound up attending that wedding. The fact that Colin Albert and Michael Proctor were in the same wedding party, I think, is mitigated somewhat by the fact that Colin Albert was about 10 years old at the time and served as a ring bearer because he was a child. So the connections that my brother tries to lay out in his affidavit, I would suggest, are not what that affidavit makes it seem. Regardless of all of that, there's still issues on admissibility and relevance under the first prong of Lampron. And the reason for that is the defense actually includes a description of this September 25th meeting between Elizabeth Proctor and Jennifer McCabe and why that meeting occurred in a state police report that it actually appends to its motion. And whether or not a court down the road agrees that that area of testimony is valid grounds for exploration for impeachment of Ms. McCabe, what's occurring here is that the defense is attempting to use that as a basis to go get another layer of even more extrinsic evidence on the hope that something that's in the phone of an unrelated third party might impeach Ms. McCabe in an area that is already potentially a grounds of extrinsic evidence for impeachment. And that is not what is permitted under Rule 17. That is a hope, that is a conjecture, and that is not the purpose of the rule. And I'm not going to belabor the point for the court because I know the court is very familiar with Rule 17, but the purpose of the rule is to bring into the court for inspection and for purposes of trial records which are going to be admitted or are likely to be admitted at trial. It is not for discovery. It is not for exploration. Whether or not that exploration the defense believes is part of its case or not. It's a question of, are those records going to be admitted at trial, and do we know they exist? And the defendant hasn't made out any of those factors at this point. The defendant is essentially assuming that there are records, does not know what is in those records, and as a basis is requesting it. And that is not a Rule 17 motion, that's a discovery motion. And with regard to that kind of last prong of Lampron, I think the defendant makes clear her basis for the request in counsel's affidavit, as I cite in my opposition. And that's thus the communication surrounding this, parentheses, and other meetings, which again, the defendant has no basis to believe there might even be other meetings, close parentheses, may reveal information necessitating further pretrial motions, including a motion to dismiss based on extraordinary governmental misconduct. And that's the purpose of this Rule 17 motion, but that's not the purpose of Rule 17. The purpose of Rule 17 is to bring into court relevant and admissible records. These records are not relevant to an issue in this case. They would not be admissible under any rule of evidence. And based on what's actually asserted by my brother in his affidavit, nothing about that assertion meets the rule of Rule 17, meets the requirements of Rule 17. The fact that communications may reveal information right off the bat fails. And the fact that they are looking for these records as they might necessitate further pretrial motions, including a motion to dismiss, is entirely anathema to Rule 17, which is designed to bring records into the court for purpose of trial. And so, based on all of those and what I lay out in my papers, I would ask the court to deny the motion.
All right. Thank you very much. Mr. Reddington, do you want to add anything? I do have your motion to join in the opposition that was just argued by Mr. Kettlewell, but do you want to add anything to that, sir?
No, Your Honor. What I would do is basically, as I indicated in the motion, is join in on the motion, noting the objection of Jennifer McCabe, obviously asserting her privacy rights, obviously suggesting, as counsel just did, that this is a clever maneuver to try to kind of weaponize Rule 17 to turn it into a discovery motion. We all know that the September 25 meeting was about harassment and what these two women had been going through on the news media with the extreme harassment that they were suffering as a result of their being witnesses on a case and cooperating with the government's prosecution of Ms. Reed. So I suggest to the court that comments like the records may reveal, and they possibly would show, which is what's in the motions that's before the court, clearly shows that there's no basis, there's no factual basis to determine that these are relevant material records other than speculating that they may reveal. Just like the allegations that the photograph of the two young kids would be Jennifer McCabe's daughters, and they're not. And it's so frustrating to the McCabe's and everybody else because they know whose kids these are. The parents know that they're their children, but nevertheless, they can.
I mean, Bob Brown, I mean, after this, I mean, I can go to specifically talking about Turtle Boy's case. Right now, I'm just focusing purely on the Karen Reed case in general, but we can move to Turtle Boy after this and see what's going on here and why he was indicted.
Suggest that this is showing that he's sitting there with these two kids that are the McCabe's children, and therefore, as counsel argues, this is evidence of extraordinary governmental misconduct, which is a wild accusation to be making at this point. And I suggest to the court that weaponizing Rule 17 is not proper. I join in the government's request initially objecting. And the fact that counsel has indicated that the government basically concedes and assents and does not oppose should not interfere with Your Honor's analysis of Rule 17 as opposed to any Rule 14 or any discovery motions that would be appropriate before the court. Thank you.
All right. Thank you very much. Do you want to respond, Mr. Jackson, before I hear briefly from the Commonwealth?
Very, very briefly. Your Honor, I would simply... to the microphone, I would simply note as to my brother's arguments, eloquent as they may be, they missed the mark. Obviously, this is relevant and admissible. Again, I don't believe that Elizabeth Proctor has standing in the court to actually argue Lampron, but since it was brought up and since that seems to be the foundation of her argument, I do want to address one point.
McElron, I'm in over my head? What makes you think that?
There's a case that was cited by my brother in his moving papers called U.S. versus Abel. It's found at 469 U.S. 45. It's a 1984 case. It does not stand for the proposition that is propounded in the paperwork. Indeed, that is a federal case, not a state court case. That's the first line of distinction. Second of all, it is a mischaracterization of the holding in Abel to say that the scope of impeachment is the outer limits. The scope of impeachment is limited to the outer limits of taking the witness's word for it. And I would simply bear upon or ask the court to review the actual holding in Abel. Justice Rehnquist does not state that the scope of impeachment is limited to, quote, taking the witness at the witness's word or taking the answer of the witness, end quote. But rather, the court specifically held that it's permissible to impeach a witness by showing his or her bias, and that's all we're seeking to do. In the court's words, Justice Rehnquist's words, quote, a successful showing of bias on the part of a witness would have a tendency to make the facts to which the witness testifies less probable in the eyes of the jury than it would be without such testimony. And that's found at page 51. Contrary to counsel's misunderstanding of the holding of Abel, our impeachment of this witness is not limited to taking Jennifer McCabe's word for it. We're entitled to extrinsic evidence about her bias, about her lack of neutrality, about her attacking her credibility. This evidence is clearly relevant, it's clearly admissible, and the Commonwealth concedes as much in its opposition paperwork. And with that, I'll submit.
Mr. Kettlewell, did you need to respond in any way? Okay, sure.
So I'm not going to debate Abel because the court can certainly read the case. But essentially, it's the defendant's burden to meet Lamprong. The defendant bears the burden to get the court to issue a subpoena and has to show all four of those factors. And it's not about whether the Commonwealth objects or does not object, and whether I have standing beyond an issue of privacy or.
Gamer for Life, if you're referring to me in terms of me attacking you for asking a question about tainting the jury pool during the DA statement, I said that I'll read between the lines. I don't think it's necessarily I don't think the DA statement was tainting the jury pool, and the reason I said that is because I don't think that there was a sufficient enough. I don't think there was anything that the DA said, because if Matthew Forrest, okay, because I was going to say, like, the defense team has been excoriating publicly about the cover up by the state police, by Trooper Proctor. I think it's equally fair that the DA is willing to make the similar statements in defense of the investigation. So that's all I was saying.
Or not, which I would argue that a third party whose records are being sought certainly does. It's a question of whether they have met those elements, and they have not.
All right. Mr. Reddington, did you need to add anything to that?
No, Your Honor, I'm good. Thank you.
Okay. All right. Does the Commonwealth want to argue this in any way?
Just briefly, Your Honor.
Okay.
Thank you, Your Honor. Not to belabor the point, but just to make the Commonwealth's position clear, the Commonwealth is not opposing. The Commonwealth, however, does not assent, does not concede anything as it relates to any sort of relationship or whatever is being termed as a close personal relationship. The relationship, as the Commonwealth understands it, between essentially Trooper Proctor and Ms. McCabe is that Trooper Proctor has a sister who has a friend, who has a sister, who has a husband, who has a brother, who has a wife, who has a sister, who is Jennifer McCabe. And it's such a close personal relationship that after apparently scouring social media, there are exactly 0 photos that counsel has produced of Ms. McCabe and Trooper Proctor pictured together at any point in time. And essentially what you have to establish this close personal relationship is a wedding party from a decade ago and some photographs of Trooper Proctor with children purported to be Ms. McCabe's children, which are not Ms. McCabe's children. But given the limited scope of what is being asked for, the Commonwealth is not opposing the motion, but would obviously request that if the court were to allow the motion, that both sides would have equal access to inspect and copy whatever screenshots are then provided by the record holders, that being the third-party witnesses. Thank you.
All right. I'll take this under advisement. Mr. Reddington, you're free to leave, but thank you for attending. You're free to stay too, but
oh, she did the thing. If I'm free to go, then I'm free to stay.
all right. So
She
now
did the thing.
a motion regarding the Commonwealth's motion for protective order pertaining to.
Okay, so as a result of that, the judge denied the defense's motion for Elizabeth Proctor's communications. she granted the communications for Trooper Proctor based on the Commonwealth's lack of opposition, in part, and she granted in part and denied in part the communications between Jennifer McCabe and Trooper Proctor. Due to the result that McCabe and Proctor are both government witnesses. Jennifer McCabe was to produce all communications, including but not limited to calls, text messages, Facebook messages, Instagram, any other third-party messaging applications or email correspondence between McCabe and Proctor between January 29, 2022 and the present. And they wanted Proctor to provide all that information between himself and McCabe between January 29, 2022 and the present. And all communications, yada, 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 between Proctor and Brian Albert and Proctor and Nicole Albert between January 29, 2022 and February 18, 2022. Do you know that Elizabeth Proctor called people's jobs and tried to get them fired over remarks about her husband? I believe that was one of the things that Turtle Boy said, right? That she was doing, due to, I guess, what people were saying about her husband. So I think that she should learn that, kind of like fight fire with fire. If people are going to say stuff about you, if you're going to make calls to people's employment and try and get them fired, you should expect the blowback, especially, given what she's been experiencing. Like, she should have expected that to happen, that they would end up calling her place of employment. Again, I'm presuming that she actually did. People are saying that it was insinuated, but there's no proof that it actually happened. I don't know. I can't tell. I'm acting on the presumption. If I were to presume that she did, then yeah, she should expect similar blowback. But again, I'm operating on the presumption that she, in fact, tried to get people fired over what she had been experiencing. She and her husband had been experiencing.
To the DNA profiles of the investigating law enforcement officers. So I'll hear from the Commonwealth first, then I will hear from counsel for the officers, and then I'll hear the defendant's opposition. Who's arguing this for the defense?
I will be, Your Honor.
Okay. All right. I will hear you, Mr. Lally.
Thank So, Your Honor, just to clarify on this, just a point I think may be misconstrued based on the defendant's opposition. This is not a situation in which these troopers have consented to anything at this point. The purpose of filing the motion was to try to gain some guidance from the court as to how mechanisms would be concerned with the collection of DNA, the retention of DNA, the destruction of DNA, and the timing in regard to that prior to obtaining either Trooper Proctor or Sergeant Buchanan's consent in relation to the taking of any bugle swab. So how this sort of arises is there is DNA reports in relation to the taillight of the defendant's vehicle. There are 3 possible contributors to that DNA mixture. One is positively identified as that of the victim, John O'Keefe. 2 others are unknown. There's been rampant sort of speculation, accusations levied against these particular troopers in regard to contaminating evidence or planting evidence and things of that nature. So the exploration of this is sort of caused by that, in the sense of the Commonwealth believes that whatever DNA comes back, it would exclude those 2 troopers as being contributors to the unknown sources of DNA. So what the Commonwealth is seeking, and the reason that the Commonwealth actually filed another motion asking for sort of an expedited response from the defendant. Is the hope of the Commonwealth, especially with March 12th jury trial date looming, was my hope was that there would be some sort of agreement that could be come to and a joint proposal to be presented to the court so the court could act on the papers, and this testing could be well underway, if not already completed, by the time that we reached today's court date. That unfortunately was not what happened. So we received the response earlier this week from the defendant. Essentially, most of the proposals that are included within the defendant's opposition are the precise alternative proposals as far as the protocol as the Commonwealth had laid it out. So as far as the defense not wishing for anybody associated with the state lab or state police to be collecting the sample, that's fine. We had proposed Ms. Christina Owens simply because she's a civilian member of the Crime Scene Services section. But if it, as long as it's a certified collector, it doesn't have to be anybody associated with that. The defendant has some issue with the state police crime lab conducting any of the testing, whether that be generating the sample or doing the comparative testing, and seems to be fine with that process proceeding at Bodie and Lorton, Virginia, where some other testing related to this case is already being done. That's fine with the Commonwealth as well. Obviously, that's going to prolong things a little bit, I would submit.
Do we know that?
I mean, what I can say is that our office would certainly be inclined to pay whatever additional.
Bob, I think Bob. I think the issue that they're raising, that people the people in the chat are trying to bring to you the argument that just because something is reported is simply because it's based on somebody's word, doesn't necessarily make it true. It could be true, but part of making allegations, part of whether or not somebody's going to take on face value the allegations that somebody made will depend on their credibility, right? And so I think you're going to find here, at least in this chat, that they're not going to find what allegations made by Turtle Boy to be credible, and so therefore they're not going to take the person's word for it. That's why they're doing the trolling thing of like, oh well, Bob Brown, he tried to get me fired at work, based solely upon my statement. So I think people are going to want, in order to corroborate the allegation that Elizabeth Proctor called the workplaces of people on Turtle Boy's side to say that she tried to get them fired, they're going to want like something more than Turtle Boy saying it or that person saying it. So they're going to want probably what's likely would be a call log from somebody's work phone, from Elizabeth, a phone number tied to Elizabeth Proctor. They're going to, or a voicemail message that Proctor may have left at their workplace that somebody was able to record. An official document from the workplace, from their supervisor, saying, we've heard of you doing these actions against people as a result of this trial, and we don't want to associate with you or some kind of corroborating evidence to back up the statements that are being made. So I think the problem that you're going to have is that if all you have are the allegations by Turtle Boy supporters or Turtle Boy himself, you're not going to get very far. I think that's the point.
Fees would be necessary to expedite that testing, but as far as the time frame is concerned, I really can't say exactly how long that's going to transpire for. But as far as it seems to be sort of the main sort of point of contention is the defendant's ability or access to the actual sample. That is something I would object to. You know, as far, particularly in this case, I don't think there's really going to be any question that the samples or the profile that's generated is the profile of the individual troopers. It's going to be collected by an independent certified collector. It's going to be the DNA profile would be generated at an independent lab. The comparative analysis would be generated at an independent lab, and counsel would certainly have access to those DNA profiles should the defendant wish to, you know, compare it to any other types of, any other pieces of evidence or any other, DNA that either they recovered during their evidence inspection or that was collected by the state police in regard to their investigation. So the need for the actual sample, I'm not really sure where that comes from, and the suggestion that the Commonwealth would have more access to it than the defendant would, especially if the court is inclined to go with the alternative suggestions of the independent collector, the independent generation of the profile, and the independent comparative analysis. I really don't see what defendant's access to the samples does or lends to any sort of credulity to the testing or to any further testing that the defendant wishes to conduct. So,
Alpha, this whole oral argument motion has been turned into state and troopers refuse to submit DNA by Karen Reed supporters. Yeah, I mean, obviously they're going to say, yeah, they don't want to, but that's how they're going to spin the argument that, oh, they refuse to provide it. Yeah, they're going to challenge it, but I'm reading the court order right here. The court order is right here on your screen, and the judge granted the defense motion, granted it based on the mutual understanding, the mutual, wait, let me see this. Let me see here. The Commonwealth moves pursuant to Massachusetts Rules of Criminal Procedure 14A6 for a protective order for the collection, use, and disposal of DNA samples of Massachusetts State Police Sergeant Yuri Buchanek and Massachusetts State Police Trooper Michael Proctor. Sergeant Buchanek and Trooper Proctor are not suspects in this case and have agreed to voluntarily submit their DNA samples depending on the parameters set forth in this order. After hearing on the matter, where attorney Gretchen Lundgren appeared on behalf of Sergeant Buchanek and Trooper Proctor, the parties are largely in agreement as to the terms of the protective order. So, according to this order, the troopers voluntarily agreed to submit their DNA test with these protections put in place. And it sounds like the protections and the protections are in agreement by both parties, both the defense and prosecution. Right. But the according to the court, I guess they're going to talk about it. The parameters of the protection order are in agreement by both parties.
So as far as that, I think really the only other sort of disparity or sticking point is the retention. The Commonwealth had suggested the end of the trial process, the reason for that versus what the defendant is suggesting as far as the conclusion of the appellate process is obviously the close of the trial process has a much more definitive end frame to it as opposed to the appellate process that could go on for months and years if not after. And given the limited nature for which the Commonwealth is seeking the consent of these troopers to conduct this DNA analysis, it certainly made more sense to myself and to the Commonwealth as far as setting that time period if the court wishes to alter that to the conclusion of the appellate process. There are other mechanisms I would suggest that the defendant could avail themselves of should they have a need for, again, the profile would exist sort of in perpetuity in their possession, at least until the end of the appellate process. And there are obviously far more mechanisms available today than there have been in previous years as to post-conviction discovery and obtaining further samples, things of that nature. So again, that was the reason for the suggestion for the end of the trial court process. But again, The purpose of this motion was to seek the court's guidance as to exactly what the parameters of that collection, retention, destruction, and all of that would be, so that that can be presented to the troopers so that they can make an intelligent decision as far as their consent is concerned.
If this were ordered to be done at the state lab, when would the results be in?
That, I think, especially given just prior turnaround time in relation to other testing that's been done in this case, at the state lab, I would hope that that could be completed within 6-7 weeks, something like that, at the most.
Well, okay. Well, Bob, can I ask you a question? Do you think that the actions Turtle Boy, I'm not going to call it harassment. That's because that's making a presumption, right? I'm gonna try and meet you halfway. Do you think that the actions that Turtle Boy did or has done or allegedly has done to Elizabeth Proctor, the wife of the investigator, were warranted? I'm curious what your opinion is as to what Turtle Boy allegedly did were justified.
Okay. Do you want me to hear from Ms. Lundgren now or after? I mean, this is your motion. Do you want me to hear from her now?
I think that's fine as far as the order's concerned.
Okay.
Gretchen Lundgren, Your Honor.
Good morning.
I think that was over the top, like media people have done. I would not have done it. I didn't ask you for whether or not you personally would not have done it. I'm asking if you believe it was moral, or you think that it was justified, in a general sense. The second thing I would ask is, can you provide me, an example of a mainstream media journalist has called Elizabeth Proctor, her personal phone and left the kind of voicemails that has been left with her, or that has been going to events where Elizabeth Proctor has gone to and has shadowed Elizabeth Proctor and the family, not asking questions, but simply with a bullhorn and making very definitive statements. Because usually an investigative journalist usually doesn't try to inject themselves into the story itself. I mean, even an embedded journalist doesn't try to inject themselves into a story.
Good morning, Your Honor. Thank you for hearing from me on behalf of Sergeant Buchanan and Trooper Proctor in a discussion as their privacy relates to the Commonwealth's motion for a protective order. The proposed protective order strikes a balance between protecting the sensitive and personal DNA information of two individuals who are not alleged to have had anything to do with the death of John O'Keefe, while giving all parties access to the resulting scientific DNA analysis. The defense's opposition casts the proposed protective order as allowing the Commonwealth to obtain, test, and analyze the samples without giving them the same opportunity, but that's simply not the case. There are areas of significant agreement between the parties here. Both parties are willing to have an independent law enforcement officer obtain.
Okay, Bob. Can you please provide me a name of a journalist and a comparable action that the journalist did that didn't result in them being arrested for harassment or witness intimidation? Can you provide me with a name?
Obtain the DNA sample. Both parties are willing to have an independent lab develop the DNA profile and conduct the comparative analysis. Both parties will receive the same reports and underlying data. Once an independent lab develops the DNA profiles, Your Honor, there should be no need for anybody to have access to the sample thereafter. And with an independent lab conducting the comparative analysis, there should be no need for anyone to have to conduct further testing. And finally, Your Honor, once the trial is over, there should be no need for those DNA materials to be on file. And as Mr. Lally said, the legislature has provided a mechanism for obtaining third-party DNA post-conviction. So there's certainly a safety net there if the DNA is needed post-trial. Your Honor, protecting the troopers' DNA samples and profiles through these procedures and protocols poses no violations of the Commonwealth's mandatory discovery obligations. The Commonwealth and the defense would be on equal footing with regard to the troopers' DNA evidence. Each party is free to argue the implication of the results at trial as they see fit. As Your Honor can appreciate, my clients are under no obligation whatsoever to provide their DNA in this matter, but they seek to take steps to demonstrate the integrity of their handling of the taillight evidence. In order to provide consent knowingly and voluntarily, they're looking for certainty surrounding who has access to their DNA, how their DNA is handled, and ultimately how their DNA is disposed of. On behalf of my clients, Your Honor, I respectfully request that you issue the protective order proposed by the Commonwealth.
All right, thank you very much. Mr. Yannetti, it sounds, when I read your opposition, I did not know that there was this much agreement. Did you when you filed it?
I did not, and quite frankly, hearing the argument from both counsel, I think there's even more agreement than I anticipated.
Okay.
Your Honor.
What do you disagree with?
Okay, so our position, Your Honor, is at this point, with regard to the DNA samples versus the DNA profiles.
So where are you in your opposition? What page?
So I'm actually going to the Commonwealth's motion itself with regard to how the DNA samples and profiles will be treated.
Okay.
We did not realize that the Commonwealth was drawing a distinction between the actual samples themselves and the profiles that were generated. It was our understanding that the Commonwealth was seeking to prohibit the defense from having access to either. But I've just
but they're not.
Exactly. I've heard Mr. Lally say today that they will turn over the profile to us. That satisfies us.
Okay, I have a question for you.
Yes.
Since you mentioned Bodie Laboratories, you're the first one that mentions it in the pleadings. How long will it take?
We're not the first ones that mention it. The Commonwealth mentioned it in their motion, and we agreed to that.
All right. I don't have that.
Your Honor, it is one of the alternatives that the Commonwealth had. I'm sorry, I can find
Okay,
them.
so we need to find the paper number. All right, but we need to know how quickly that can be done, and we need to see about expediting it.
Typical for Bodie, just because I've recently gone through that with regard to the hair sample.
Right.
It's, I think, like a 12 to 14 week turnaround without any sort of expedition. So, you know, expediting, I don't know that necessarily that can be cut in half, but it is something that I think can be turned around a little bit quicker than their typical turnaround time.
And Ms. Lundgren, you'll have your clients available, at the drop of a hat to provide this sample? All right, so go ahead, Mr. Yannetti.
Thank you. So, Your Honor, I think the only real conflict at this point, if the Commonwealth is holding to their motion, is their paragraph 7, which states the defendant is not permitted to conduct independent analysis or testing with either Sergeant Buchnick's or Trooper Proctor's DNA samples or profiles. Now, clearly, we won't do that with regard to the samples because we won't have them. We don't need them. But we will have the DNA profiles, Your Honor. And once we do, they, in my view, in my client's view, we should be able to use them for any case-related purpose. We have no interest in, distributing them anywhere or doing anything with them.
Hold on, Ms. Lundgren, I think you should answer this. Why don't you come on up? Is there an opposition to that?
I just need you in front of a microphone. There's one right here. Thank you.
She could take this mic if she likes.
No, because we'll be going back and forth, so you should stay there.
There is an opposition, Your Honor. I mean, I think perhaps the Commonwealth can speak to it. I think there's also a strategic decision, a case-related decision. Certainly, we agree with the privacy interests that the troopers are providing their DNA for a specific reason and with regard to a specific item in this case. And they do want to limit that consent. However, that is more, I believe, a case-related and strategic reason that I would also defer to the Commonwealth to speak to.
All right, I'll hear from Mr. Lally afterwards. Go ahead. Not now. I'll hear from Ms. Giannetti to finish.
Right. So there is other evidence in this case.
I was actually planning on watching at least one of Little's videos to kind of see where she's coming from in her perspective. Like I said, I'm trying. I know. Obviously, I think Christine is pretty fair in saying that I'm kind of looking at the record through the eyes of the prosecution. I'm not gonna, and I think that's a fair assessment to make, and I'm not going to deny that. But I also still, again, I want to rely on what's in the record, and I want to rely on, what is intended to be put into the trial, into the upcoming trial. But I also do want to see, I'm curious to see what Melanie Little, and her perspective and what she's saying. But Thea, I guess for the purposes of Reed and eventually when I talk about January 6th, the no politics rule, I mean, I'm taking that out for those limited purposes because it can't be helped. Politics is going to obviously be a part of this. And so I think it's unfair for me to talk politics without giving people who may oppose my opinion to be muzzled. So I think that's fair. So for the purposes of today and any of the January 6th stuff that I want to cover, we're going to put the kibosh on the no politics rule.
Where comparative.
But who the heck is Jennifer Coffin-Daffer? What in the world is that last name?
DNA testing could be done. And in addition, Your Honor, I want to make it clear that our investigation has been ongoing and is ongoing to this day. We may come into possession of evidence related to this case, physical evidence, that we may want to do our own comparative testing on. And once those profiles are released, assuming that...
Look, man, J. Edgar Hoover did nothing wrong. Hashtag.
Consent, and that the Commonwealth comes into possession of a DNA profile, and the defense does as well by Mr. Lally's admission today. That should be evidence that either side can use for any proper purpose that is case related. So we should not be prohibited from either requesting or doing our own comparative analysis from those DNA profiles if it relates to the case.
What do you want to say, Mr. Lally? We're talking hypotheticals here.
We are.
Right.
So what I would say is the only other identified evidence really, or the bulk of it as far as DNA is concerned, concerns Mr. O'Keefe's clothing, which I don't understand what any relevance that would have pertaining to the troopers' DNA profiles. As it pertains to what ifs, as far as any sort of other physical evidence that counsel would come into possession to, the protective order, while somewhat ironclad, is not necessarily cement. So if there's a request for a modification based on subsequent evidence or something like that, I think that's something that the court can obviously entertain at that point. But really, the purpose of this is with reference to that one specific item.
It does make sense that if there is something later, you come before
Thank you, Taco, for the $2. Much appreciated.
me on it.
Well,
so that's why I asked you if it's hypothetical. If you have an item that you want to test, I think the Commonwealth has every right to know what that item is.
Okay, our position would be that we should be able to conduct our own investigation in private and reveal the results of those investigations, should we desire to. We have a different ethical duty than the Commonwealth. Clearly, if there's any evidence that the Commonwealth possesses that we'd like to do comparative testing on, we have no choice but to notify the Commonwealth and resolve.
Melanie scoffed at my premise that it's not weird to refuse to speak to officers while intoxicated and enter yourself to an active homicide investigation near your house. I mean, I feel like that'd be true. Isn't Melanie Little a defense attorney? I feel like that would be an advice that any defense attorney would probably say. To not volunteer yourself. And you saying I invite the glarer on your program. Who the heck is the glarer? I genuinely don't know who that is, but I mean, if they want to talk about the case, fine, sure.
Resolve any disputes before this court. But if we come into possession of anything that we believe is related to this case and should be tested, we don't believe that's any business of the Commonwealth to interject in that. We will have the profile at that point. We can do our own testing and then reveal the results of that testing should we desire to.
All right. Does the Commonwealth want to be heard?
No, Your Honor.
All right.
Maybe we have just a quick second, Your Honor.
Yep.
Oh, see, he's a Turtle Boy orbiter.
My co-counsel brings up a good point, which is after months and months and months of requesting access to the physical evidence, we finally appeared at the Norfolk County DA's office on December 1st of 2023 with our forensic DNA collection expert, and he did swabbings of multiple pieces of evidence. So we do have those in our possession.
All right. I had no idea what you were talking about when you were saying hypothetically.
Well, there are two separate issues. There are the items that we've swabbed that we should be able to test, and if we have the DNA profiles of these troopers, there should.
All right, give me 1 second. I'll be right back, guys. All right. All right, here we go.
Should be nothing prohibiting us from testing him. And by the way, the Commonwealth has the ability to do the exact same testing on their own. And then if there's any other evidence, I still maintain that we should be able to do comparative testing on that as well.
All right. Let's get the samples going. Let's do that, and I'll figure out the rest of this. But let's get who do you have in mind for an independent collector?
Your Honor, I don't have anyone specific in mind, but most local police departments have at least someone who is a detective who is a certified collector. Is
there someone the defendant? The two of you work out something.
I don't have any issue with working out something with Mr. Lally.
All right, so let's do it today.
That sounds good.
All right, and Ms. Lundgren, you'll make your witnesses available immediately?
Yes, Your Honor, but I just, for sake of clarification, just trying to understand, and as Mr. Lally said, they have not provided their consent yet. They are waiting to hear what the boundaries of the proposed protective order will be in order to provide that, knowing and voluntary consent.
Okay.
So, I mean, we could certainly potentially do the samples and hold them in abeyance and not release them if the court was willing to have them destroyed should the troopers decide not to provide consent based on the bounds of the protective order. But certainly I think they do need to know what those terms are before moving forward.
All right. I need to look at this. I'll do it as quickly as I can. All right. Is that it on this?
Yes, Your Honor.
On this motion, yes.
All right. So the third and the fourth motion are sort of in their own category. So the third motion is, it's interesting in that I received the opposition, or the opposition to motion for protective order was filed before the motion for protective order, as I had it in the docket. Who's arguing this for the defendant?
This is the protective order regarding the letters, Your Honor?
Yes.
I will be arguing.
All right, so so what I can say, Mr. Yannetti, is that it appears that you served counsel for the Commonwealth with this motion, but you did not serve the U.S. Attorney's Office.
Uh-oh.
So the U.S. Attorney's Office has a right to be heard on this order, on this proposal that you have. So I need them here. I need them served. So you can serve them and we'll get a date.
That's fine, Your Honor.
All right, and we'll do it as soon as possible. I do not want to change the trial date in this case. This case will go to trial on March 12th. And the fourth motion, where I said the third and the fourth are sort of in the same category, the Commonwealth's motion for records from Boston Magazine, that needs to be appropriately served.
Masshole, thank you for the $10. TB is currently in jail, detoxing off of amphetamines and calling his victim mentally unstable. Over under on him doing the full 90 days. I don't know. That's a good question. I'm not sure how Massachusetts operates with its with their bail.
Have someone here from Boston Magazine if they oppose it.
Yes.
So I'd like to do this as soon as possible. And given our trial schedule and the fact that I intend that we try this case in March, like everybody served for a hearing here on January 18th at 3 o'clock in the afternoon. It's a Thursday afternoon. So it's just about 2 weeks. Should give you enough time if you serve these people today to get them here.
Can you do it?
We can do it via Zoom where it's
Your Honor,
discrete issues, yes.
we're in trial on January 18th. It's a short trial. Is there any other day that might work for the court?
I don't see any time that we can.
Is the 16th at all possible?
No.
No, we're in, no.
Oh, that's back of the holiday, isn't it?
We're both.
That was a very strong no.
It's not available. We started trial Monday.
We're both supposed to be in trial that day.
All right, so you can do it via Zoom, or Mr. Yannetti can do it.
I can certainly do it. There's no chance of the 23rd, Your Honor?
No, there's no chance that week.
Okay.
If they had been served, we would have gone forward with that. I'm more concerned about that one, getting that one rolling, than the other one, all right?
What the hell?
So January 18th at 3 o'clock. All right. Anything else we need to talk about? Doesn't appear to be.
Your Honor, I think it makes sense to raise this one issue, which is today was the filing deadline for all non-evidentiary motions.
Right, and none have been for evidentiary motions.
Okay.
Today was the filing deadline for evidentiary motions, motions to suppress, things like that.
I understand. So the defense will be filing before the end of business today, not evidentiary motions, but non-evidentiary motions to one motion to dismiss and one motion for sanctions and also for disqualification of the Norfolk County DA's office from this case. So,
all right, so you are not filing motions to suppress.
Correct.
So they're being waived.
Was on court TV.
All motion.
I did see that Melanie was on court TV.
Evidentiary motions are waived.
Correct. Well, yeah, we'll have pretrial motions in limine. I don't know if they.
I didn't see the whole of it, but I did see that she was a guest on court TV.
Okay, but everything else, so,
in terms of constitutional issues.
So file them by the end of today, and if we can hear them on that date, we'll do that on the 18th.
Right.
I didn't want to watch it because, again, this is before I started going through the case and through the motions. And again, I didn't want to further cloud or further I don't know how to further bias my opinion one way or the other, more so than it already did at that point.
And that would depend on Mr. Lally's ability to respond, et cetera, which I understand he may need some time, but they will be filed today.
Okay. All right. Thank you all.
Your Honor, there's several I apologize. Your Honor, there's several housekeeping matters I wanted to address with the court. In regards to the motions to dismiss that Mr. Yannetti, my brother, just discussed, we do have a motion to dismiss the indictments in this case, and I wanted to lodge the grand jury minutes with the court. They are very voluminous. I wanted to ask for the court's guidance on how you would prefer to receive those.
So when that happens, we typically get them on a flash drive.
Who is Jennifer Coffin-Daffer? Who is this Coffin-Daffer individual?
As well as Jimmy, how are they filed with you?
Counsel have filed by email and then followed up with the grand jury minutes.
Yes.
They can do it by a thumb drive.
All right, so a thumb drive, but get a separate one for
We'll
me.
mail that to you so that you'll have a hard copy, the thumb drive. The other housekeeping issue I wanted to address with the court, Your Honor, is, as you know, the court has ordered the Verizon records relating to Jennifer McCabe, as well as the Google Nest records. We were informed by the clerk's office those were supposed to be produced to the court on December 15th. My understanding is you guys have not received anything, and I wanted to follow up on that because that obviously is evidence that we hope to have in advance of trial.
All right, so Mr. Clerk, is your office call or is counsel call?
I've never called.
Yeah. So typically defense counsel calls and says there's a court order, where are these records?
I emailed the clerk's office, and they said that they haven't received anything yet, and so that's why I wanted.
Right, so call Verizon and call, who's the other record holder?
Google Nest.
Contact the record holder and say there's a court order, where are these records?
Okay, but
Okay.
you all have not received anything.
I don't know. Jim?
Yes, I'm thinking.
Have you received them?
Could counsel come to sidebar?
Okay.
Absolutely.
Sorry. Hello, Philip. Nemo, I haven't seen that where that there's some people have said that Karen Reed made some kind of outburst against a judge at a hearing. I mean, is there any video of that? Or is that like a rumor? I don't know. I mean, I could do the poll, but I imagine that right now a lot of my viewers are probably going to say she's guilty. I could put a not sure, but I feel like people are going to put in not sure. But I want to get people's actual, where are they leaning towards right now?
The court, just one last thing, just with regard to the motion to dismiss, as far as does the court want the exhibits that were presented to the grand jury in addition to the minutes, or just the minutes?
Yes, I assume where you say it's so voluminous, it's the exhibits as well, Ms. Little?
I can produce.
You have to stand in Massachusetts. Thank you.
I can produce the exhibits as well.
Okay. All right, so everything.
And I don't have a problem providing that to the court as well. I don't want to duplicate matters, but if it's easier, I can do it. It's fine.
So those would obviously be provided under seal, Your Honor.
Of course, they're grand jury minutes.
Correct. That's with regard to the motion to dismiss, the basis of which is the grand jury presentation. The separate motion.
Is it McCarthy or Odell?
Both.
Okay.
With regard to the second motion for sanctions, Your Honor, the letters that were the issue of the protective order that the Commonwealth moved for, that we've now put off, those will be part of the quote-unquote evidence with regard to the motion for sanctions. It's our position, obviously, that those are not exempt from public disclosure. However,
I'm going to keep them exempt until we hear from the U.S. Attorney's Office.
That's why I raised the issue, Your Honor. I just wanted
was that your suggestion as well, so we could get moving with this motion to dismiss?
Of course. Thank you.
All right. Thank you.
Thank you, Your Honor.
Court will rise, please.
All right. Let me see here. Oh, is this so in this are they both in here?
Chris, Julie, again, brother of Brian Albert. Brian Albert and Nicole, they have children, Caitlin Albert, Brian Albert Jr., and then there's a friend of theirs, Julie Nagel. Then you look at Nicole Albert, her sister, another important name in all this, Jennifer McCabe. Jennifer McCabe, who's married to Matt McCabe. So this is the house. So the night that John O'Keefe got out of the car in front of the house and either went to the party or was murdered or run over by Karen Reed, who was in the house? Take a look. This is what's alleged here. Brian Albert's there. Nicole is there. Chris and Julie are not there, but their son, Colin, is there, which is Brian's nephew. Their kids are there. Brian Albert Jr., Caitlin, and their friend Julie. Also there, very significant, is Jennifer McCabe and Matt McCabe. All of this, trying to understand the names, the relationships, and does it all lead to some conspiracy, bias, framing, planning evidence? Let's bring in our guests. Joining us in New York City, attorney, podcaster Melanie Little is with us. In Boston, Massachusetts, criminal defense attorney and author of the books Super Predators and Law and the Tough on Crime Myth, Peter Ellikin is with us. And down in beautiful Jacksonville, Florida, retired FBI Special Agent Jennifer Koffendorfer. Great to have everyone here. All right, Melanie, I'll begin with you. So
here we go.
So is the defense really predicated on the fact that Trooper Proctor, who was at a wedding and his family is close with the Alberts, is literally planting evidence to literally frame Karen Reed for murder? Is that what the defense is saying here, Melanie?
I think that's exactly what they're saying, and they're also saying that there are a lot of questions of fact here. You know, if Trooper Proctor, who was the lead investigator,
I hate to interrupt you. I just want to preface our entire conversation tonight. I'm not concerned about reasonable doubt. Okay, reasonable doubt. That's. I want to know about the truth tonight, because the defense is saying John O'Keefe was murdered by people in that house, and the prosecution saying he was murdered by Karen Reed. So I want to look at these as two cases and evaluate what's going on here. Let's begin with the defense case. So Melanie, go ahead. I'm sorry I interrupted you. But I understand this is a case that's going to be tough with reasonable doubt. But I want to get to the truth tonight. So what do you see in terms of these relationships? Is that enough? Like someone would do this? Frame this woman?
Well, I can't see why anybody would find it so beyond the pale that it could never actually happen. I mean, if it is true that Michael Proctor, who's the lead investigator on this case, has close ties to the Albert family and to the McCabe family, everyone inside that house was a relative except for one person. So if the defense can show that there are close second family type ties between everyone in that house and the lead investigator on this case, that could be something that definitely could lead to reasonable doubt. I know you don't want to go there, but that's exactly
again, I'm not concerned about the reasonable doubt tonight. Not tonight. When we get to the trial, I'll get to it. I'm trying to figure out the truth here, Peter, because I've got Alan Jackson, a former prosecutor who was amazing out in California, jumping up and down literally on the courtroom steps, telling us that the prosecution has it all wrong. The DA has this all wrong, and that it's the police who are responsible here.
What they had, I shouldn't have the turkey without like something to drink.
Well, yeah, first of all, I'd say that there was such a conflict of interest here. Even the appearance of bias, I don't know why Trooper Proctor was in charge of this investigation. There's just too many ties we saw that we just...
Well, the defense is saying he's in charge because he's framing Karen Reed. That's why. He's not going to give up the lead on this because he's got to save, you know, his friend and his friend's son and whoever else they're going to allege did this and frame somebody for this.
Yeah, and I guess that's, I think we've all been seeing enough cases over the years that it's not absolutely beyond the pale that some police officer may not be truthful. So,
wait, there's a difference though. This is...
I was going to say, I think there's a strong difference between a police officer lying or planting evidence or fabricating a story, which is obviously that has happened and can happen in a country of 330 million people. It wouldn't be surprising that it happens, you know, a lot in this country, frequently, given the size of this country. But there's a difference between that and an officer explicitly working with witnesses to actively frame the case, knowing that somebody else did it and actively framing somebody else for it.
There's a difference between not being truthful, forgetting something, and literally taking evidence and putting it somewhere so you can frame someone for murder, take away their liberty, and put them in jail for the rest of their life. This is different than just making a mistake.
Do that to protect a friend, though, or your long-term friends with the family? We saw it goes way, way back, and his mother is saying that the Alberts are a second family to her, and we have one of the family members, Jennifer McCabe, going to his house. Who goes to a state trooper's house, whole personal home to go chat with them, and it's not even reported in any paperwork. So with those kinds of biased ties, would there be a motive? Could anybody do that to protect their friends, to protect people you've known for years? And
That's also true. The defense's theory rests on more than just Trooper Proctor. It also relies on the lab techs, the medical examiner's office, the DA's office, lots of people who don't have a similar familial connection to the Albert family, as terms of working conjunction in order to frame Karen Reed.
that's why when the DA here has said that it's a lie if you see any connection between him and the family, the facts just don't bear that out.
Yeah, that was baffling. And I'm glad you mentioned that. Let's take a listen to Alan Jackson today talking about that meeting on September 25th of last year.
On September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem.
Okay, Jennifer, let me ask you, should we be concerned, when I say we, the public, that the DA comes out and says there's no relationship with the family here, Proctor had nothing to do with what was going on that day, and it seems that that's not necessarily true, and then McCabe going to Proctor's house? I mean, should there be some concern here?
I think it's very important to truly understand the relationship. Brian Albert, who lived in the house where this incident occurred out in the front, his brother's wife's sister was friends with Proctor's sister. Okay, that's how far removed. I just hope your audience, the
One more
attorneys
time,
that are
one more
present-
time, one more time.
Okay.
We'll do it
Brian
together.
Brother's wife's sister was friends with Proctor's sister. Okay, that's how far removed. In other words, I could tell you, I have no idea who my sister-in-law's sister's friends are. I mean, there's no way. I couldn't tell you one of them. I don't even know my sister-in-law's friends. And we're very close. So my point is, this is how far removed it is. And then it's, again, Proctor's sister. Detective Proctor, I'm sorry, Trooper Proctor and Brian Albert, the home again, they had never even met each other. The pictures you're showing are his brother's family, And again, that's through this, removed relationship. So I think it's very important to understand that just because you have a Proctor there and an Albert there, they're not the same family unit. Second of all, everybody's forgetting about Brian Higgins. That chart, you're missing the ATF agent that was there. And that's very important too. So to have this conspiracy work, we have to have a Boston police officer, Canton Police, EMS, an ATF agent, the medical examiner's office, the district attorney, and the state police all combined to do this huge conspiracy against who? Nothing against Karen Reed, but who is Karen Reed?
But who?
Is no one special other than she was dating in a relationship that was falling apart, the victim deceased.
Okay, everyone stay where you are. We've got to hit a quick break. Quick break.
Coming soon.
The Doomsday
Media.
Love you.
Free Karen Reed! Free Karen Reed!
All right, folks, there's the scene. Like I said, you don't see this. You just don't see this. So Matt Johnson, as we saw, has been up there this week. So he went to the neighborhood and is going to walk you through the story again. It's a very complicated story. And again, there's actually two stories we're talking about at the same time. What the prosecution says happened, what the defense says happened. Take a look.
We're here in Canton, Massachusetts.
Like my primary issue with this, and I'm trying to think of this in a practical sense of, you know, people who would participate in this. The people who are participating in this have so much to lose. So much to lose if they're going to participate in this. These are people's careers, their jobs. You'd have their livelihoods to cover for people that some of them are friends. Obviously, the Alberts and the McCabe's are going to be related to each other. But you want Proctor to cover for a relation that he has like a 6 degree of separation in terms of relationship. It's strange credulity that they are willing to risk their career for that. But you know what? People have also, you know, committed heinous crimes where they had a lot to lose. So, I mean, that's not too much. I mean, in fairness, I mean, there could be a lot too. But, but I mean, when you come to Proctor, but then you're looking at the medical examiner and the EMTs, and like they have a lot of to lose. If they're going to go with this to try and protect, again, either Colin or Brian.
This is just outside of Boston. And on January 28, 2022, Karen Reed and John O'Keefe went out drinking. They went drinking here at the Waterfall Bar and Grill. Later that night, they decided to meet up with a couple of friends that were at a bar down the street. It's about a block away now, and they make their way over here to C.F. McCarthy's Bar and Grill, and they meet up with Jennifer and Matthew McCabe. Around midnight, the bars begin to close, so everybody is invited back to Jennifer's sister's house, which, according to GPS, is about an 8-minute drive. Let's go check it out.
Wait, what am I doing? I thought they were going to talk to each other more. Is that it?
Tony, which case
There
is
we go.
easier to prove? That he was murdered in the house or that he was murdered by Karen Reed?
I have so many questions. I think it's easier to prove that he was murdered in the house.
Tell me
in my
why.
opinion. I mean, where's the dog? Where's the dog? I saw the photos of John Proctor.
Is that like a hashtag for Karen Reed, folks? Because it feels like every new Karen Reed person that comes into the chat, literally the first thing they say in chat is, "Where's the dog? Where's Chloe?" Like, is that like a hashtag?
Right arm that were taken at his autopsy. They have what clearly looks to me to be like animal scratches on them. All of a sudden, the family.
According to you, I mean, for me, I'm not going to say one way or the other because I'm not an animal bite expert. I'm not a canine officer. I'm not anybody. I don't own. My family owned a dog, but I never personally owned a dog. That's me. I would never say one way or the other, and that's why I'm like, I'm more going to rely on the opinions of experts and people who are going to testify, people who have a lot to lose. Bob, I know that Christine also said that they had an animal expert, that Melanie had an animal expert. My question is that, is the defense counsel going to bring that person in to testify, or are they going to rely on Sheridan, the other expert? I feel like if I'm going to be the defense, and if I'm going to rely on it, I would want to have very, very strong and definitive expert to come in and testify to the injuries or to the injuries or wounds that O'Keefe had to dispute. Well, Alpha, I don't know. Wait, the expert was a canine handler, I would assume that if they're going to have I assume Alpha. Well, my presumption is like if I'm going to say that it's an expert, my assumption is going to be that it's a forensics expert, like a forensic examiner, who has done research, and so I think that's what the defense is relying on. I think the forensic examiner that the defense is relying on is like an actual forensics examiner, and not just simply a canine handler.
A dog of 7 years. They had a German Shepherd in the house. The family dog is gone. They rehomed the dog. The dog is missing. The dog's DNA cannot be tested to see if those were in fact animal scratches. You know, there's a cocktail glass allegedly on the lawn. They never searched the inside of the house. Why did they never go inside the house to see if they had those type of glasses inside the house? Why was the basement flooring ripped up? The house was sold. Why did...
Well, again, my understanding from the motion, my understanding from the Brian Albert's attorney was that the reason why the floors were ripped up was because that they were doing a remodeling to eventually sell the house. And they explained that most of the family, extended family had, or excuse me, not the extended family, most of the family of the home left the home, and so Brian Albert and the missus, you know, were looking to downsize because they don't need like a 4 or 5 bedroom house.
This police officer who owned the house and his wife never come out of their house to look at the scene when there is a dead police officer on their lawn. I have so many questions, and I think at the end of the day, the jury is going to have to decide the facts. And if we have so many questions from looking at these facts, I think a jury is going to have a lot of questions too.
Jennifer, which case is easier to prove?
Oh, without a doubt, the case that he was hit by Karen Reed. She had the motive. These are not dog scratches. That has been said by 2 medical examiners, separate medical examiners that examined him. Also, there were samples sent to a lab in California to test for non-human or canine DNA. Negative. So I find it so interesting that people want to look at a picture.
Wait, I would like to see that. But well, the thing is, I wish I could see what Jennifer said, because I don't remember seeing that, and I wish I could see that, but I don't think those examinations are on the docket. Because I would like to, yeah, I want to see that the second medical examiner's report, or even the first medical examiner's report, and I want to see the results of the DNA test, as to whether or not there is non-human DNA on those marks. But I didn't see that in the docket, and I kind of wish I could see that.
Sure. And all of a sudden, they're medical examiners, they're doctors with PhDs, and they can say these are dog scratches. Second to the point there, Brian Albert, they sold their house months and months after that. Also, they had a leak downstairs in the basement that resulted in quite a lot of damage, and that's why the flooring was replaced. As far as the dog, Chloe got into a fight with another dog in that neighborhood. And during that fight, one of the neighbors went to separate the 2 dogs and was scratched or bitten. And it was decided amongst the people that they would go ahead and rehome the dog as opposed to making an even larger deal out of it. So there are very logical explanations, but these are the types of innuendos that have been completely blown up.
All right, the poll's been going on for almost half an hour. So the currently, according to chat,
shows is that, I mean, that's...
Sorry. What's currently saying is that the 80% of chat believes that Karen Reed is guilty of some kind of a criminal act. Okay. she seems to know a lot about these people. Lula, everything that Jennifer what's her face just said is in the record from the attorney for Brian Albert. She's not. Are you insinuating that this Jennifer individual is also part of it? The statements that she said about the dog being rehomed and the house being remodeled and sold, it was all in the Brian Albert's attorney's motion. They've already added Jennifer Coffindaffer into the conspiracy. Oh. Okay. What was the other one I was going to say? No, she is so defensive of them. Well, I mean, if you're, I don't know if you're capable of looking, having empathy. I'm capable of having empathy for Karen Reed, the potential for her being railroaded by the system. I can see that. I think it's entirely possible. But are you able to come from the position that, because I mean, are you looking at Melanie Little being and her being very aggressive in terms of accusing the Albert family of committing the murder, but you can't see how a person from the opposite end would relate to these spurious allegations being made against the family by a defense team that is doing everything in their power to cast the Albert family in a negative light. Like, I mean, if you're going to be very defensive of Karen Reed, can you also see how people are going to be defensive of the Albert family if they believe that they're being unfairly targeted or unfairly accused of the crime? Was it Melanie Little? Okay. Okay, so is this the expert from 2 days ago? And even she has merch. I need to get off my ass.
Police officer who owned the house and his wife never come out of their house to look at the scene when there is a dead police officer on their lawn. I have so many questions, and I think at the end of the day, the jury is going to have to decide the facts. And if we have so many questions from looking at these facts, I think a jury is going to have a lot of questions too.
Jennifer, which case is easier to prove?
Without a doubt, the case that he was hit by Karen Reed. She had the motive. These are not dog scratches. That has been said by two medical examiners, separate medical examiners that examined him. Also, there were samples sent to a lab in California to test for non-human or canine DNA. Negative. So I find it so interesting that people want to look at a picture and all of a sudden they're medical examiners, they're doctors with PhDs, and they can say these are dog scratches. Second to the point there, the Brian Albert, they sold their house months and months after that. Also, they had a leak downstairs in the basement that resulted in quite a lot of damage, and that's why the flooring was replaced. As far as the dog, Chloe got into a fight with another dog in that neighborhood. And during that fight, one of the neighbors went to separate the two dogs and was scratched or bitten. And it was decided amongst the people that they would go ahead and rehome the dog as opposed to making an even larger deal out of it. So there are very logical explanations, but these are the types of innuendos that have been completely blown up.
under
Innuendos,
the watchful eye of one of our own
innuendos that have
experts,
been
which we did
blown
not have the
completely
advantage of doing at any time prior.
up.
It turns out
And
that it wasn't a human.
after that appearance, I started to think
on-
that maybe I was in the Twilight Zone. Maybe I was wrong. Maybe maybe this absolutely did come from a car. But having handled motor vehicle accidents and dog bite cases for the entirety of my 30-year career, I knew that I wasn't crazy, but I needed some validation, not only from you, because all of you, I believe, feel the same way that I do, but I wanted to go to an expert, a canine trainer, someone who is retired from the Miami Police Department, who has a YouTube channel with over 1.7 million subscribers. And he's here today. But before we go to Garrett, I want to show you, refresh your recollection.
A dead body in front of the house is not probable cause to search for house. Well, based on my understanding of where the body was located, it was right at the far corner between the two properties. I genuinely don't know where the property line is. But it was right at the cusp between the two properties.
Election as to the timeline of events here that the defense showed in court as part of the motion hearing argument to obtain the animal control records of Chloe, the German Shepherd owned by Brian Albert and his family. So here's the exhibit that was shown in court by the defense with a timeline. February 2017, this picture was taken with the family, the Albert family, and here's a little picture of Chloe. That's all that we really have. In 2019, the Albert family registers ownership of its German Shepherd, Chloe. January 29th of 2022, John O'Keefe suffers what they are saying is not animal scratch and puncture wounds, which are unexplained by the prosecution. And here's a picture that was taken at autopsy of John O'Keefe's right arm. In May of 2022, the defense began its investigation into the injuries of John O'Keefe. And then also in May of 2022, the Alberts inform the Canton Animal Control that Chloe was allegedly rehomed out of state. And here's where they were at present when this was shown in court. The Commonwealth continues to, can't read what that says, release the defense access to tissue samples obtained from O'Keefe's arm for DNA analysis. And we did go over that. We looked at the emails between the attorneys. Either the tissue samples were lost or they were never taken. And without further ado, I am going to bring in my guest for today's show, Garrett Wing, who has a YouTube channel. I have linked his channel below. And please give a warm welcome to our guest, Garrett. Hello, Garrett.
Hey.
I'm trying to find right now I'm trying to find the defense's both the defense's motion for Rule 17 motion for the animal control documents and then Brian Albert's attorney's response.
Thank you so much for coming on the show. Why
Yeah,
don't
my
you tell the viewers about your channel, tell us first about your background and your experience. And I just want to point out from the get-go that Garrett is not the kind of expert that could testify in court as to dog bites, but we are going to ask him and pick his brain with regard to his experience.
So then why would we so then why should we care? Right? I mean, like, I see people in my chat in my comments saying, "Hey, I've been a dog owner for something years. I've been I've dealt with a lot of different. I've seen a lot of different dog bites in my time, and there's no way these are dog bites, and there's no way." And I'm like, "That's fine, okay, but I don't believe you." The same way that I don't believe a similar other random Joe saying that those obviously are dog bites or dog scratches. Like, I don't care about a layman's opinion. I care about somebody who is willing to testify to their expertise in a court of law that they know what they're talking about under penalty of perjury.
In his dog training, dog handling, police dog training, his experience of observing dog bites throughout his very long career. And we are going to get some information from him that way. Okay, so I'm going to give you the screen. Go for it.
Sure. Because he's not an expert.
For that. And a not for nothing, I can pretty much guarantee you I've seen more dog bites than most any medical examiner. And I would say that because.
But you still can't, but you can't testify in court. I don't know why you're. Okay.
People don't often die from dog bites. Very rare, even police dog bites, which can be very serious and very gruesome. So I don't think medical examiners get to see a lot of dog bites on dead bodies. It just doesn't happen. Now, if we're talking about gunshot wounds, then I'd be a little bit out of my league there. But when it comes to dog bites, I can't even tell you how many I have seen. We're talking dog bites on humans, whether it's on a suspect, or we get a lot of what we call accidental dog bites in training. When you're training and working with police dogs, you play with fire, sometimes you get burned. But to kind of set the stage with my background, my father was a police canine handler since 1981 with the city.
I mean, I'm not going to sit here and dismiss this guy's everything that this guy says. Obviously, as a canine handler, he is, in fairness, going to have more experience seeing bites on people than the average layman person. So I'm not going to completely discount his statements. But that's what they are. They're his statements of his they're statements of his opinion that have some level of credibility, but obviously not enough credibility for him to be able to testify in a court of law.
City of Miami Police Department. I was born in 1983. And so when you are born into a home of a police canine handler, the dog is like your pet dog. It's there 24/7. So I grew up with police dogs. My father had 5 dogs in his career. And obviously I lived with my father the entirety of my childhood. So not only would we have one police dog in the house, but anytime that first police dog would retire, then we would replace it with the next police dog. And so we typically would have one retired and one active police dog in the house at all times. And again, just to give you more of my background in it, because when you're in police canine work, it's not just a job, it becomes a lifestyle because you bring the dog home with you, as I said earlier. And so I would go often with my father to police canine demos, bring your kid to work day. And my first experience actually taking a bite from a police dog on a sleeve was at the age of 8 years old. I took a bite from what was at the time my family pet, but was actually my dad's police dog. We were doing a demo for some kindergartners, and he said, "Hey, Garrett, my partner didn't show up today, and we want to put on a good show for the kids. Could do me a favor, put the sleeve on and go hide in the bushes." And I was actually like a little freaked out because I'd never done it before. And I told him, "Hey, Dad, I haven't taken a bite before." But having been in the game so long, my father was actually a little taken aback. He's like, "What do you mean you haven't taken a bite yet? Of course I've taught you how to take a bite from a police dog." I'm like, "No, not yet." He goes, "Well, today's your day." So that was the first time I took a police dog bite at 8 years old. And fast forward to when I was 16 years old, I started doing police ride-alongs with my father in the city of Miami. We're talking like late 90s. And late 90s city of Miami is very, very action-packed. A lot of crime going on, a lot of action in the city. And so our very first night out, working midnight shift in some of the super go-getter, and spent 20
Okay, I don't care.
years case. And very long story short, I see locates him and gets, and needless to say, from that point forward, and I already knew I wanted to go into police dog bites than most police officers would see in their entire career, because not for nothing, the police canine unit is a very tight-knit community, and they don't trust even regular police officers to come in the backyard with them, to go on searches with them. They find that police liability than an asset, and very much community or the canine unit usually hand selected to go in the back because it's a very dangerous job. And so anyways, at the age of action dog handler, this is post 9/11 2001. Excuse me, I'm going to switch my earphones. post 2000, post 9/11, 2001. And so all of these big corporations are really freaked out about terrorism and especially bombs. And so I got a job with a company called Garrison and Sloan, still in business today. They hired me. I was trained by my father to work as an explosive ordnance detection handler, which is a bomb dog handler. And I worked at the Port of Miami, Port Everglades, where we would sweep all of the materials going on the cruise ships, Royal Caribbean, Norwegian Cruise Line, et cetera. So super cool job for someone at my age, only 18 years old. Had security clearance to work along the quest to have that. And I got no first real hands-on Dutch Shepherds, actually destined to become police dogs, to be police agencies with tips I was working. So all of these dogs were fully trained. I did that for a couple of years. City of my decades. My mother, stepfather, to be hired with that agency, and officer was to get in the canine unit, and you have to put in 2 years minimum with our agency. Years canine unit, which was really cool because at that time my father completely life growing canine I can remember, and we would go to things called the Pig Bowl, which was I was at the age of about 22, 23 years old. Brought in a new lieutenant. They brought in me as the senior supervisor, and we had to kind of clean house. The unit had kind of been.
Oh my God.
Long story short, I was no longer in the canine unit, but I had to get my fix. And I got my fix by starting a couple of companies specializing in, well, the company was American Overwatch Canine Services, and we specialized in, that was my first venture outside of police work, where we would travel the country, and our mission was to make police canine handlers and their dogs just be better at their jobs, make sure that they did the best that they could, because it's a super high liability unit. And one of the specialties that we would teach is high risk, excuse me, getting interrupted by a phone call.
Always.
As always, always, but high risk tracking for armed and violent offenders. And that was our specialty. And we also would do a street worthy class, which was,
okay, I get it.
Guess what? The focus of that class was just to get dogs to basically engage and be tougher and bite harder on the street. And so that's just a little sprinkling of my background. And now we actually specialize in pet dog training. Of all the stuff my background is, civilians or pet dogs that need training. And so that's what we specialize in now.
Well, I hereby deputize you as an expert in canine dog training and handling, and you are, as far as I can tell, very qualified to speak on this subject. So many people, tell everyone, first of all, what your YouTube channel is, what the name of your YouTube channel is.
American Standard Dog Training. You can also find us on Instagram, TikTok, Facebook, American Standard K9.
Right. And you have 1.7 million subscribers, so good for you. You'll have to teach me the secrets one day. A lot of people in the chat are saying that that somebody says, no, Chloe had no canine training. She was a rescue, just a reactive house pet. Not sure about that. Somebody says that she was a failed police dog because of her aggression.
Wait, is that actually true? I honestly feel like a lot of that's BS. I feel like both the defense and the prosecution wouldn't identify Chloe as a canine if she wasn't in fact a canine. They would just say it's a German Shepherd. Like, I don't buy that at all. When both that neither the defense. Oh, if Chloe wasn't a police dog, then why does everybody say that it's a canine? Although, in fairness, okay, the attorneys are quoting. The attorney's quoting the defense attorney's statement that he called it a canine, but the defense attorney, but Albert's attorney isn't identifying the dog as a canine. A canine, as in a K9, as in an actual police dog. But Kate saying that while it's a German Shepherd, it's not a canine, as in an actual police dog. K-9. Okay. Yeah. Okay. But Chloe wasn't actually a police dog. Okay, I was actually under the impression that she was a police dog, but either active or retired. But I guess not.
Somebody said she was a police dog in training. And how many Lexuses have you seen with a dog bite upgrade? That was just a funny one that I put in there. Janine says, I was under the impression Chloe was a failed police trained dog. So what we want to do is talk about both scenarios. How a German Shepherd specifically would behave as a trained canine dog, and how one would behave if it was a household pet, and how one would behave if it was a failed canine dog. And I know that you have some video to show us. So let me know which one you want to handle first.
Sure. So I think the first thing that stands out to me, so I'm assuming, and I don't know too much about the case, I don't know too much about the dog. Chloe, I'm assuming this is a female dog?
I would imagine if her name's Chloe, but if anybody knows for sure.
Yeah, and the reason I bring that up is it's extremely rare to have a female police dog. It's very, I think in my entire career I've seen 2. Extremely rare. Takes a very special. It takes a very special dog, period. But we usually pick the males because of that testosterone. They can handle it a lot better.
Is it? I feel like we've seen a fair. I mean, it's body cam footage, so selective bias and all. But I feel like I never heard of this idea that police departments almost only rarely take female dogs as canines. Is that true? Do canine units prefer male dogs? Let me see. This is from the National Police Dog Foundation. Do they use only males or did they use females for police service dogs? Males and females both make excellent service dogs. Guys, I'll be right back. 1 second. And then this is from K10workingdogs.com. Canine dogs are either male or female. Depends mostly on the purpose of the future canine dog. Most canine dogs that are used are males. However, female dogs are more and more used as canine dogs as well. Where male dogs are often more aggressive and stronger, female dogs can be used as service dogs as well. Female dogs are often used as single-purpose dogs. For example, trained to detect bombs, drugs, or other contraband. Male dogs often picked as police dogs. They show more aggression, stronger. You cannot say a male dog is better than a female dog. It simply matters how the canine will be assigned to work with you. So there's two. I mean, so it sounds like doesn't sound like they're like it's super rare, but it does seem like they're I guess for the canine police work that there is a preference for male dogs. Okay.
Because it's a tough job. So and not to say the female dogs can't do it, it's just very, very rare. So it's possible that she was a washout. We do have a lot of police dog washouts. They typically are washed out for what we call bad nerves, meaning they can't handle that stress. They can't handle the gunshots, the violence. We would do simulated type of, we actually do tremendous amount of testing. We can go deep on the testing of just what it takes for us to even select a potential candidate to get enrolled in a police canine program, which takes anywhere from 4 to 6 months. Once we take the dog, still 4 to 6 months of training all day, every day to get them qualified to even hit the street. So we like to do a very robust testing process before we even take the dog in. And I can dive into the details on what some of this testing might be, but one of the things would be just testing the nerves. Can the dog handle the stress of a simulated encounter with a bad guy?
It seems it's been confirmed through the animal control records that Chloe was actually a female German Shepherd.
Okay.
So.
Yep, a female German Shepherd does not make it a police dog, though.
Does that change your opinion at all? Or let's move on from here. Let's see what videos you have and what you can show us about what a German Shepherd attack would look like.
Sure. So I came across this video just in my own research of what I do daily. We do a lot of reviews of dog bites and dog fights and things like that. So this is fairly recent. This is actually from my hometown where I grew up in South Florida, Cooper City, which is a small town out.
If I could get you a licensed PI to talk to you to help explain the role of the PI in a criminal defense, would you? I think it may help put some of this extraneous stuff into perspective. I mean, I'd be open to that, yeah. Hit me up, either email or DM.
Outside of Fort Lauderdale. And so I'll share my screen here. And this is a delivery driver, fairly recent. I'd say this is 3 or 6 months old. She comes and delivers a package. I guess she left something, so she comes back. And you're going to see a German Shepherd that I am very confident has little to no training. This is not a police dog.
Okay.
And you will see, because what I want to kind of frame here is you don't need to be a trained police dog. You don't need to be a trained protection or, quote, attack dog to be a dog and bite someone. There are a lot of dogs out there biting people left and right with little to no training. And when we get into it further and we talk about the actual injuries, it actually plays into the dog that if he was bit, that doesn't look like a police dog bite.
Okay, so the record doesn't look like it.
But let's go ahead and show you this video and see what you all think about it. And it's a little gruesome. I'll warn you now.
Yeah, trigger warning.
Rough. Yeah.
Trigger warning for anybody who's sensitive to this.
I'll get to the part where this is her after the bite, and I want you to kind of pay attention to the type of injuries you're seeing. And the thing that I want to just continue to point out is the type of injury. A lot of people think of dog bites are puncture wounds. It's very rare that a dog bite is a puncture wound. They are often lacerations. Think of it as sticking a knife in and pulling, because naturally that's what dogs do. They bite their prey and they pull. And or if you were to get bit by a dog, the very first thing you'll try to do is pull away, and it creates those types of injuries. So let's go ahead and go into the video here. This is after the woman is bit. She's in her car and she's a little shooken up, and you can see right here, and we'll play it in a minute, but this is not a puncture wound. This is a laceration from a dog bite. And then
dog attack.
Watch how quickly this goes down. Again, very confident that this is not a protection dog. This is a German Shepherd doing what German Shepherds were bred to do for hundreds of years. Protect their home.
That attack captured by her own dash camera.
All I can say was, help me, help me. I thought I was going to die.
Deanna Riveros needed more than 30 stitches.
I'm going to go back to that. See the laceration?
Yeah.
That's not a puncture wound, but we're all pretty clear this is a dog bite.
Yep.
She got bit. The weight of the dog alone biting and trying to pull its prey down to the floor, and her potentially pulling away. is what causes this, especially too, and we see this a lot in police canine work. When the dogs bite, we are actually taught to provide what's called back tension, and it makes the dog bite harder. And or when you see police canine handlers who aren't as good as they should be, when they go to remove a dog off of a bite, they're often doing what's called a choke off, and you can call it a choke off. It's more of like a rip off, and they will actually grab the collar of the dog, especially these really high prey drive, just high drive dogs in general, which we train all day, every day. And we're basically telling never let go. Hold on, no matter what happens, don't let go. And oftentimes you'll see police dogs, this is a story for another day, but they often do not let go on the first, second, third, fourth, fifth command because they're like, make me. And so you're forced to pull the dog off, and it creates really, really bad, nasty lacerations. So we'll play this just a little further, but you can see how quickly this, in my opinion, is completely untrained German Shepherd just goes right into action.
I just want to point out, wait, just stop for 1 second.
Sure.
I want to point out that you said lacerations and that the medical examiner in her report calls those injuries abrasions. Abrasions.
Not an abrasion.
No.
Nothing close. That's not.
Wait, has he seen the medical examiner's photos? I mean, he's stating that no, what that image was not, that was a laceration. But is Melanie, but I feel like he's answering the question like, no, those are lacerations. Is he talking about the photo from this incident? But has he seen the photos from the medical examiner to say whether or not those were lacerations?
That's not like a curb rash or street rash, or you fall off your bike. We've all been there, a scraped knee. There's no abrasion there. There's just straight up lacerations and potentially some puncture wounds. This may be a slightly different angle. Just watch it again and we'll move to something else. But look how quickly this dog doesn't hesitate to jump in.
So I went back to her house.
When the door opened, a dog pushed past its owner.
I see the video and I'm just like, I don't understand how I escaped.
She was knocked to the ground as the dog kept biting into her body.
I just look up to the sky and I say.
And I'd also say that this interaction probably lasted no more than 15 or 30 seconds. So imagine what a dog bite looks like when the fight takes place over 2, 3, 4, 5 minutes. You're going to get a lot more damage.
And this is the dog attacking the dog's owner. Yeah, this is not.
No, this is a dog. This is attacking the delivery driver.
Okay, all right,
coming back. But we often do see, and I don't know if the owner suffered injuries too. Sometimes the dogs will redirect on their owners. If anyone's ever tried to break up a dog fight, you find out real quick how quickly you can get bit when the dog's in a frenzy like that. But no, this is the dog attacking just an Uber delivery driver, just knock, knock, and the dog just jumped into what we would kind of refer to as like a territorial drive. Who are you? This is my pack. You don't belong. Let me defend my turf. But again, my point being, that's about an 85-pound German Shepherd. I don't know if it's a male or female. It doesn't really matter. Just how much damage can be done from a pet dog, what we would consider a power breed. And German Shepherds are often considered a power breed, meaning dogs that pack a punch and don't necessarily need to be trained to bite. That's what they do. They don't have hands, really. They use their mouth to explore their world and defend their territory.
Wow. Okay.
Okay. Looking at the
next video.
The Canton animal control motion from the Commonwealth opposing it.
Let's see. I think we'll start with the video and then I'll show you kind of the aftermath. Let me pull this up. I think we have one ready to go here. These are what we use. I don't even know which. There's so many cool videos to show you. This is some behind the scenes stuff that we don't normally share. But I thought your viewers would find it interesting how we get police dogs to bite and kind of the mechanics of the bite.
Okay, so I'm looking at the Commonwealth's opposition to the animal control records. Okay, they don't refer to it as Chloe as a canine either. So it does seem like the only one the only party who is referring to Chloe as a K9, K-9, is the defense. Okay, so I was wrong there. I thought both the Commonwealth and the defense were referring to it, but I think the opposing parties were simply quoting what the defense was saying and not saying it for themselves.
Some of the, like I said, the equipment that we use, and I actually brought some.
Oh, yeah.
So if this interests you at all, let me know. But this is a typical bite sleeve, and we use this basically to allow the dog to bite as hard as they want, but to protect ourselves. These come in different grades, thicknesses, and they get thinner and thinner or thicker as you need them. But as we start progressing and trying to get the dogs to actually, one of the hardest things to teach a police dog to do actually is bite human flesh. It's very hard to do because dogs, generally speaking, are man's best friend. And so to get them to actually go from biting equipment to actually biting real human flesh, some dogs, it's a very easy transition. Those are those harder dogs, a little bit crazier. But most of the time, we actually have a hard time getting them to commit to a bite. And so a dear friend of mine, actually, Steve Sprouse, who's been in the police canine world for probably almost 4 decades, invented this equipment that I want to show you now.
Mm-hmm.
And his company is called Arm & Lagan. And what he does is he creates these prosthetic limbs specifically made for teaching police dogs how to bite. And this particular one has a little bit more than a handful of bites on it. The idea here being we set up a scenario, a training scenario with a bad guy. I'll play the bad guy, let's say. The dog, by the way, does not know it's a training scenario. That's the ticket. That's the trick. In all dog training, by the way, whether it's pet dogs or police dogs, they don't know whether they're training or not. We try to make it as real to life as possible. So the dog comes out, we hide, dog finds the bad guy, and the only thing we try to make available is this, because this is the only thing stopping us from getting really bit. There's no other protection. And I want to show you, you see the lacerations that are caused from dog bites? You're not really seeing punctures. It looks as if this was stabbed with a knife. Now that's the closest to a puncture. But for the most part, it's ripping. It's a ripping type thing. Dogs bite and they pull. And at the same time, we are naturally pulling back to create our own back tension, which is exactly what a rabbit would do in the wild. You know what I mean? A rabbit doesn't, we call them, there's no such thing as suicide bunnies. If a bunny or any other prey item is getting bit, their whole objective is to get away, get away, get away. And that's where you get the lacerations that happen. So that's one piece. And here's another one. By the way, tell me if this doesn't look
so I missed this.
Kind of similar to something we may see a little later. Pretty.
Okay, so they're going to show it later.
This was just a funky mold. But again, look at the lacerations. And I have to kind of spread it because of the material, but they're more like cut wounds. And you can see the angle, right? It's pretty consistent depending upon how you present it. So hopefully your viewers find that pretty interesting.
Yeah, that's really interesting.
And if
would there go ahead? Let me just go ahead. Finish before you, and then I'll. Would there be?
If you wanted to see a video of a dog actually doing it.
Yeah, we do totally. But we're saying, could you explain bite marks on one side of the arm? Maybe can't see all the photos, and Jo could have wounds under. Sorry if duplicate. I have not seen any photos of the inside of the arm. So let us know in your experience what you see in these types of dog attacks.
Sure. So yeah, sometimes you will not see like a mirror image of the bite. Sometimes it really is. It's just like you see here. It's very hard to tell where the top tooth was, the bottom tooth was.
Trying to find it.
The matchup. Those top canines tend to do the most damage. But it's very hard to match up. Like, is this the top? Is this the bottom? Is this from one bite, or is that one canine? Is this a different bite? Very tricky to tell. It's not like a vampire bite, where it's 2 here and 2 here. It's never looks like that. And one of the hardest things to do, one of the not fun parts of my job as a police canine supervisor is writing bite reports. I cannot tell you how many bite reports I have done. And one of the parts of the bite report that is very important is to document in as much detail as possible the actual injury. And so, yeah, you could say he had a dog bite on the arm. Yeah, but it was actually, and this is, trust me when I say this,
F.
How do you have a 3 laceration dog bite? Meaning sometimes the dog bites are pretty straightforward. It's a single bite. And when we look at the injury, it's 1 or 2 cuts here and 1 on the bottom. And then I'm like, I'd have to call the canine handler like, hey, correct me if I'm wrong, man. Is your dog missing a canine tooth? Which happens. Sometimes they get pulled out, ripped out, whatever. He's like, no, I just got all 4. I'm like, well, I don't know how we only got 3 lacerations, but sometimes the dog's coming in at an angle. It's not always just a perfect bite. And the other thing that you see with untrained dogs or dogs that are, whether it's a police canine washout or it's just a dog who doesn't know how to bite, wasn't trained to bite, is you will see what's called shallow biting. Shallow biting is when they only use their canines to bite, and it creates a lot more of those lacerations versus police dogs, trained dogs to bite. We teach them to bite and hold and bite deep. And so, because what we don't want is a police dog to do more damage than they need to, right? We have a suspect that's refusing to say, come out. I don't want the dog going in there and just biting and letting go and biting and biting. Next thing you know, you have to explain, why was the guy bitten 8 times? The cleanest, best bite that we are looking for is what's considered a bite and hold. 1 bite, I don't care how long the fight takes place. It can typically last anywhere from 15 to 30 seconds, though some guys want to put up a longer fight. 2 or 3 minutes, which would be extended. But even if it was a 2 or 3 minute ordeal where the guy's all out fighting with the dog and we're struggling to get him in handcuffs, we're looking for 1 bite, 1 hold, and not all up and down the arm. But that takes a lot of work to get a dog to do that. What we see, and these are the dogs that get washed out, are the what we call nervy dogs. They're more like jabbing with their teeth. They'll reach out and bite, but they don't commit to the bite. And again, if they're not trained to bite and hold and they haven't built up that grip strength and they're not biting deeply, then it's very easy to pull away from the grasp of that dog. Very easy to do that, which then the dog re-engages, and that's what can create a scenario where you have multiple bites. And
let me see here.
That's the first thing that came to mind. And in fact,
is there actually the motion?
When I shared the photo, the autopsy photo, and should I share it now so we can refer to it?
Bring it up.
Yeah. When I shared this, actually, knowing I was going to come on here, and I was unaware of the case, but the photo itself is very interesting. Let me see if I can pull it up. You know, I don't know if I'm going to be able to. Yeah, this should do it. I think this will get it done here. Yeah. Just bear with me as I pull this up.
Sure.
Hey, Kate, do you have a copy of the defense's motion, Rule 17 motion, with the Canton Animal Control? I don't see it in the group that you sent me. I have the Commonwealth's opposition to it, and I have their Rule 17 motion again for Brian Albert's communications. But I don't have the actual motion for the records from the Canton Animal Control.
All right.
And who are also trainers who themselves have seen countless bites. Probably between us, we've seen, hundreds each. And I didn't say anything. I said, what are your thoughts on this? And they said, there was zero question that this is a dog bite. Zero question to them. Their thought, though, was that this was a police dog that probably should have been washed out. This is not what we want to see on a police dog bite. We don't want to see constant re-engagements, which is what this looks like. But this is what I would expect from, like, that German Shepherd we saw bite that lady, the delivery driver, right? Just naturally going in, doing as much damage as possible, not understanding the mechanics of biting deep and holding. These, in my opinion, are bites utilizing the front of the mouth. Furthermore, I had seen video, and I could be wrong, but when Mr. O'Keefe was last seen on that surveillance camera in the bar, It appears like he's wearing a long sleeve shirt, almost like a sweater, maybe.
Yeah, somebody was asking that exact question, so let me pull up that exact question, but keep going.
And this is exactly indicative of a dog, and we see this even with trained police dogs, when someone's wearing baggy clothing or long sleeves or jeans or
54.
a jacket, you're gonna get these more shallow bites. The dog's constantly trying to get a grip on the prey, and of course the prey item is moving away, and you're gonna get these. This is what's considered shallow bite marks. This is the dog trying to get a grip, but the only thing that's sinking in are those.
Yeah, 54 is not in the folder. It goes from 51, 52, and then goes straight to 58. So we don't have dockets for 53, 54, 55, 56, and 57. Oh, the check the spreadsheet, the motion's impounded. Ooh. Ah, okay. All right.
Front teeth. And the biggest thing that kind of stood out to me, I don't know if you can see my cursor or not, but this bite right here, I'm even calling it a bite. I'm trying to stay objective here, but
okay.
These look like, and you see this a lot with shallow bites. What it looks like is this is maybe the left canine, maybe the bottom right canine, or the canine here, but these.
Is there a way for you to enlarge that photo on your
see.
screen? Yeah, there we go. It's a V
This looks
shape.
like the front teeth. Think of the dog's.
Okay. So I'm not really seeing much here on dog laws. That's fine. Nothing to do with the case. On bite rules in court. Let me see. What does she say? So there was one here that she had as well, where she's saying that the Commonwealth now has a new theory.
This is the Commonwealth's
affidavit in support of Commonwealth's motion for record filed on January 4th. Very recent. Impounded, I guess it is the Massachusetts lingo for exempt from disclosure. Commonwealth motion to impound, almost motion for records. All right, so what is she saying here?
This is the Commonwealth's affidavit in support of their motion for these records. Just want to enlarge this so you can read it along with me, or if you're just listening to me, then you can just listen to my voice.
All right.
Commonwealth versus Karen Reed. Affidavit in support of Commonwealth's motion for records. My name is Laura McLaughlin, and I'm the Assistant District Attorney assigned to move for the production of records in the above captioned matter. The defendant is charged with murder, manslaughter while operating under the influence, and leaving the scene of personal injury death. As found by the grand jury, the facts underlying the charges are as follows, set forth in the Commonwealth statement of the case. Okay, so this is the latest statement of the Commonwealth's case as of the date of this filing with the court, which was January 4th, 2024, which is
Okay.
nearly 2 years post incident.
Sure.
On January 29th, 2022, at approximately 6:04 a.m., the Canton Police Department received a 911 call from a woman reporting a male party, subsequently identified as the victim John O'Keefe, found in the snow outside 34 Fairview Road. I'm going to break to tell you, if you don't know, the victim, John O'Keefe, was a Boston police officer with the Boston PD. Nowhere in the records does it ever mention that in any of the official records. Never mentions it in the police report. None
Okay.
of the records that I've seen ever mention that he is a Boston police officer, and I'm offended by that.
Why?
Personally offended by that because I 100% back the blue. I have members of my family who are active and retired law enforcement, and I find that to be disrespectful. In fact, when the 911 call was made by Jen McCabe, she did not even say, my friend John O'Keefe, Boston police officer. It's never mentioned. I back the blue. And
Wait.
the victim is a police officer. Keep that
Okay. Can you
in mind. At the time of
do you have an example like another from another incident where an officer was killed? And in the state's statement of the case, they explicitly identify him as a police officer? I mean,
the 911 call, there was an active blizzard occurring with heavy snow and the temperature in the teens. Officers Saraf and Mulaney, both of the Canton Police Department, were dispatched to the scene along with Canton Fire and EMS. Officer Saraf was the first officer to arrive on scene, where he observed 3 females waving at him from the front yard area of the residence.
females.
Officer Saraf's cruiser camera footage captured his arrival to the scene. The footage depicts the weather and visibility conditions during the officer's transit and arrival to the scene shortly after the body of the victim was discovered and the 911 call was placed. In the video, Officer Saraf attempts to locate the calling parties in the darkness and blizzard conditions. Okay. Questions?
Okay.
It seems to me, from my reading of this, that they are talking about dash cam footage. I don't know if there's anybody in here from the Canton PD who knows whether they are referring to dash cam footage. There's no reference.
I thought there was. I thought in the original statement of the case, there was a reference to dash cam footage. Hang on. Officer Saraf's cruiser camera footage captured his arrival to the scene. I thought they did. Hold on. Statement of the case. So no, this wasn't in. This is a statement of the case, so that's not there. I wish these things could be that you could search for words in this PDF. Pull up behind me. Tab. Reviewed. There. See the backside. Yeah. Let's see here. I could have sworn. Maybe it was from reading from this one, the one that they're reading here. Let me actually take a look at this because I could have sworn in the states and further statements from the state that they did refer to the dash cam footage long before this January 4th motion. Commonwealth's order for protective order of an interview. Give me 1 second, guys. I'm sorry. We're kind of learning this as we go. Okay. I mean, that's the whole point of this, right? Just trying to figure out what's going on with this case. Karen Reed, Commonwealth's notice of discovery, affidavit support, motion to inspect the tail lighting. John O'Keefe's clothing. Affidavit support, discovery. Reservation, power minutes, Office of Chief Middle. June 9th, 2022. Massachusetts General Order on body cam footage. You can't, not when the PDF is like just simply scanned. You can't do a word search. Yeah. The PDF has to be specifically modified to be able to search for the words. Yeah. I will actually laugh. Oh, here we go. In this August 12th, 2022, defendant's motion to compel this production of materials listed in Commonwealth's Notice of Discovery 1 in number 127, Canton Police Department cruiser camera video. So, in the Commonwealth's Notice of Discovery 1, item number 127, they explicitly talk about that there was a cruiser camera video. And this is from June 10th, 2022.
To body cam footage.
Wait.
Do no reference to body referring to, who knows whether they're referring to dash cam footage. There's, from my reading of,
Oh my God, wait, what?
that they are talking about dash cam footage.
Yeah?
I don't know if there's anybody in here from the Canton PD, who knows whether they're referring to dash cam footage.
Cruiser camera footage is dash cam footage.
There's no reference to body cam footage. Do
right?
Canton PD officers wear body cams?
I have in one of these, there is, where was it? That there was a body cam, there is a body cam footage. But it wasn't from the scene of the crime. I think it's referring to an interview that was an interview with a witness or somebody. Hang on. Curriculum vitae. State police report, state police report, state police report, SRT report, crime scene, services, crime laboratory, cell phone. I know I saw it. Surveillance video. Driver history. CV. Cell phone extraction. Cell phone records. So in the first discovery, there's no mention of body cam footage. But this, yeah, I don't know why she's talking about body cam footage when it's obviously that cruiser camera footage is obviously explicitly talking about dash cam footage, which is listed in the defense discovery 1, dated June 10th, 2022. And then okay, so it looks like compel production of preservation of geofencing data. That's fine. And then this is from August 12th, 2022. Defendant's motion to compel production of materials listed in Commonwealth's Notice of Discovery 1. And on number 127, they say that they reference again the cruiser camera video. And then where was the other one I saw? I know I saw it. I know I saw it. A reference to the body cam footage. Here we go. Copy. This is from Commonwealth's Notice of Discovery 2, dated August 12th, 2022. Copy of Massachusetts State Police body-worn camera footage from June 9, 2022, one flash drive. So it sounds like from January of, so it was Massachusetts State Police from January 9th, 2022, which means that it was probably an interview. And then a copy of Massachusetts State Police General Order, body-worn and cruiser-mounted cameras.
And if they do, where's the body cam footage? They're only referring to this video that says his cruiser camera footage.
Okay.
Obviously, we haven't seen that because that is evidence for later during the trial.
Right.
But I have concerns. Okay.
About what?
No body cam, says Olivia. Thank you, Olivia. Olivia, I know we keep missing each other. We're like two ships in the night.
No, and so even their chat is saying that the Canton police officers do not have body cameras.
Michelle says also they have no body cams. Angela says, shouldn't they all?
Yes, I agree they should. I agree they should, but body cams are expensive. Not just the cameras themselves, but the cost of storing and retaining the footage is expensive. So obviously not a whole lot of smaller-ish police departments can afford them.
Is in the chat. Lieutenant Peter is retired. NYPD. Canton PD does not have body cams. Okay. And Olivia says, yes, Melanie, they're referring to dash cam footage inside this Canton PD. Is on Twitter as Olivia Lamba to back all this stuff up. Follow her on Twitter if you have not done so already. We are trying to connect so that she can come on this show and do this with me, but we're both busy, I guess. All right. So now we know Canton PD does not have body cams, but they do have dash cam footage, and that's what they're referring to here.
Okay.
Back to the document. Looking at the residence of 34 Fairview Road from the street, 3 females were in the left corner of the property in the area of a flagpole and fire hydrant. Officer Saraf observed the victim lying on the ground as 2 of the females were performing CPR on him. The 3 females on scene were identified as the defendant, Karen Reed, Jennifer McCabe, and Kerry Roberts. Officer Saraf also further observed the victim to be cold to the touch and not breathing. He returned to his cruiser to retrieve his AED device. However, at this time, Canton Fire and EMS arrived on scene and took over resuscitative efforts. Paramedics transported Mr. O'Keefe to the Good Samaritan Medical Center in Brockton, where he was subsequently determined to be deceased by Dr. Justin Rice hours later. Lieutenant Paul Gallagher, Detective Sergeant Michael Lank, and Sergeant Sean Good, also of the Canton Police, arrived on scene moments after the 911 call had been received. Following the victim's transport from the scene, they began to search for any evidence in the immediate area around where Mr. O'Keefe's body had been discovered. In the mounds of snow on the front lawn of the residence adjacent to the roadway. They located pieces of a broken cocktail-style glass and multiple patches of red that appeared to be blood in the vicinity of where the body had been located. The Canton officers secured the glass and 6 blood samples from the snow as evidence. I'm going to break here for a minute to say to you,
Okay.
this. 6:04, Jen McCabe makes a 911 call to say that there is a man passed out in the snow. Man, not my dear friend, not a Boston police officer, not hysterical, very calmly. There is a man passed out in the snow in front of 34 Fairview. We haven't had a release of the 911 call. That is what the 911 call is alleged to have said. After the 911 call, Officer Saraf pulls up in a cruiser with dash cam footage.
Okay.
3 women on the lawn, one of whom is screaming bloody murder and hysterical, performing CPR and mouth to mouth, which they don't say. They don't say mouth to mouth here. They just say CPR.
Okay.
Saraf goes back to his cruiser to get his defibrillator. That's AED is a defibrillator, like a portable defibrillator. Paramedics show up. Fire truck maybe shows up. It says Canton Fire. And 3 more officers show up. A lieutenant, a detective sergeant, and another sergeant. And with all of this flurry of activity going on at 6 a.m. on the front lawn of 34 Fairview, the homeowner, Brian Albert, who is at the time a detective sergeant at the Boston Police Department and member of the Fugitive Task Force, and his wife, Nicole, who is the sister of Jen McCabe, who's outside on the front lawn, never come out of their house. They never come out of their house. All this activity is happening. What is also interesting here is that they do not indicate that they borrowed a leaf blower from a neighbor to search for evidence, that the patches of red that appeared to be blood that were located were collected in red Solo cups that they also obtained from a neighbor. These are glaring omissions in this statement of facts that I just want to point out to you. His body was found 12 feet from the curb. Somebody says literally 30 feet from the front door. And if you
All right. Let me see here. um 12 feet from the curb. I think that was one of the officers who made that statement. I'm curious. Their distance there, here. Well, this is a crude estimate. Very crude estimate. Let's say it's 20 feet. Let's say it's 12 feet from the curb. Again, I'm not gonna. This is Google Maps. We don't know. Oh, I'm not even showing you. Hold on. Not working. There we go. So this is about 12 feet from the curb, right? Right here to here. Again, this is, and then if you drag, it's about to the front steps of the house is about 67 feet. So a bit of a distance away. This would be 30 feet, which would be much more damning. Yeah. Body was right here. My understanding. The far corner of the property. Allegedly right here between the fire hydrant and the flagpole. So the body was around here or so. This is not 30 feet from the door, but okay. So not literally 30 feet from the door.
Owned that home, whether you were an police detective or not. And a person who was invited over to your house the night before for your after party after midnight is dead on your front lawn. Do you come out?
But they, according to them, they never showed up.
Logic, common sense.
But they never showed up. If or we're assuming what Jennifer McCabe said was true, and that they never actually showed up at the house, why would they think to look outside?
Why didn't they come out? Did they slept through it? But there was so much noise out there with the leaf blower, at least 2 police cars, fire, EMS, paramedics, hysterical screaming. Dog doesn't bark. Thank you, Snatch. Dog doesn't bark. Chloe, the German Shepherd that they had for 7 or 8 years, the family dog, doesn't bark. Juries do not leave their common sense at the door, and neither do we when we're reading court documents. So, yeah, Debbie, how did they stay inside? Red flag to me. Why would they not come out?
Well, wasn't it still blizzard conditions at the time when they found the body?
Mike Sweeney, originally the prosecution was saying that Karen consumed 8 to 10 drinks in an hour based on her credit card being charged for those drinks. Karen's like 110 pounds. Yeah. Maybe she bought around. How many people were there at the waterfall? A lot, because we're going to find out. Let's keep reading.
Well, my understanding is that the troopers estimated the number of drinks she bought not just the receipts, but also from the security camera footage from the bars, right?
CC. If you don't want your DNA found or be seen on video, then you stay inside. Oh, this Boston police officer, Brian Albert, also allegedly had no cameras, or they weren't working, or the Ring doorbell footage. That's missing too. And I'm not accusing him of anything.
You are accusing them of everything.
Proven guilty, and I 100% believe that. But I think a jury's going to have a question. Just saying. So again, Canton PD. By now we have 1, 2, 3, 4 officers on. Oh no, 5, because Officer Zaroff shows up with Officer Mullaney. So they're Canton PD, the first 2. Then we've got the next 3 that show up from Canton PD: Paul Gallagher, Michael Lank, and Sergeant Sean Good. 5 of them are searching the scene where this dead fellow police officer is found. And the only thing that they could find is a broken cocktail glass and 6 blood samples from the snow. That's all they found. It is not going to be until later, when the Massachusetts police gets involved, that all of a sudden more evidence pops up. And I'm not accusing anybody of anything. Common.
So then you are saying like both the Canton Police Department and the Massachusetts Police Department are in on it.
Sense-wise, what does this say to you?
I don't know. That you're
Later
kind of
that morning, the Massachusetts State Police Detective Unit of the Norfolk District Attorney's Office was notified and responded to the Canton Police Department. Trooper Michael Proctor and Sergeant Yuri Buchanak were among the troopers who responded and began interviewing witnesses. After leaving the Canton Police Department, Trooper Michael Proctor and Sergeant Yuri Buchanak were among the troopers who responded and began interviewing. I just read that. After leaving the Canton Police Department, they first spoke with Ms. McCabe at her home. Question for those of you who are local, because there's so many of you. If this was initially determined to be a homicide, who would get jurisdiction of it? And if it was initially determined to be a motor vehicle accident, who would get jurisdiction of it? Canton PD or Massachusetts State Police? I have questions.
Well, I don't know. Are you? Well, isn't that something that you would want to know, right? Instead of asking for chat, which, no offense to you guys, I love you. I would not rely on chat to provide that answer for me, right? Has there been is there an explanation as to why the Massachusetts State Police took jurisdiction? How much can posts like this hurt the case for both parties? Not a whole lot. Not everybody is terminally online like we are. So I wouldn't say that this is like going to substantially affect the case. For either side.
Right. At her home, they interview her, Kelly, at her home, at Jen McCabe's home, not at the police department. Not
Okay.
taped, not even
What?
recorded, I don't think, in any way.
Okay, that's fine. Is there?
Not even voice recorded.
I feel like I don't know. Understand why you don't think that the what? So what makes? Well, did they interview Karen Reed at the police department? The initial interview? I don't think so. Did they? Hang on, let me. They first spoke with Miss McCabe at her home. Okay, so they first spoke with Miss McCabe at her home. They then interviewed Matthew McCabe and say, you know, where he was, maybe, I guess, also at the home. They also interviewed the homeowners, Brian and Nicole Albert, at the home. They interviewed Brian Nagel, I don't know how to pronounce the name. Doesn't say where in this reviewing. And then they later that day they interviewed Miss Carrie Roberts. They don't say where. Also assuming it's at a home. Proceeded to view the Good Samaritan, to view the victim. They conducted an autopsy. At 4:30, the troopers went to, on January 29th, they went to the home of the defendant's parents. So they interviewed her at the home as well. They interviewed the defendant at her home as well. So why are you creating this major level of suspicion that they interviewed Jennifer McCabe the day the day of the incident, when it sounds like the troopers interviewed everybody else at their homes as well, including the defendant, Karen Reed.
Okay, so the state police take over if they're declared, somebody said. Unattended body goes to the state police. Okay. What time did they take over? So he was pronounced around 7:40, 7:50 a.m. Okay. All right. Okay, cool. So then all suspicious deaths go to Massachusetts State Police. Thank you for that. Every state runs differently, so it's always good to have people in the chat who know. Scott says he was alive on the lawn. I've heard from medical people who tell me that because the body was cold, they could not pronounce him until the body was warmed up. So I'm not sure if he was still alive or not. They said he wasn't breathing. I don't know if they got a pulse. We don't have access to a lot of those records yet. We'll get them at trial, but we don't have them yet. So I'm trying to go by what we have. No recording whatsoever.
Okay. Is there a recording of Karen Reed's interview? No. So then so far everybody's on an even playing field. What the why is she doing this? You're not we know why, because you're trying your best to like put all the onus on McCabe and the Albert family. But if there was something suspicious about it, you would note, like, unlike Karen Reed, who instead of McCabe or Roberts or the Alberts, she was in fact interviewed by the police. She was taken by the police to the police station and was interviewed there rather than at the comfort of her own home or at her parents' home.
Norsk, I see you tagging me in all your tweets. I can barely keep up, but I thank you. Brian Albert had Google Nest. Where dat? Where's that? Yeah, Magnolia Gypsy, I noticed this too. Not even signed by none of the witness statements are signed. Some of them are dictated. Some of them are not dictated or printed out until a month or two later. Some of the witnesses aren't even interviewed until 18 months after this.
Okay.
Just pointing these things out to you, my friends.
Just asking questions.
Okay, so after he was pronounced, that's when they called in state police. All right, let's keep going because this is like 29 pages. So they go to Jen McCabe's home to interview her. Ms. McCabe indicated that she and some friends were at the Waterfall Bar and Grill during the evening of January 28th. She arrived with her husband Matthew at approximately 9 p.m. following one of their children's high school basketball games early in the evening. That is the first time that I am seeing anything from Jennifer McCabe, why they're calling her Ms. McCabe. In some of these witness statements that they took from her, they call her Jen, which seems to be a little bit friendly.
Which witness statements?
You call somebody Jen, you call somebody Jennifer when you're a police officer, trooper taking a statement.
Wait, what witness statements? Do you have those? Is that in the file? Let me see here. Statement of the case. Would it be in the statement of the case? No, not in the statement of the case. I mean, does she have access to these witness statements or not? I'd be curious to see that, right? Hang on. Like, because you have to, if you're wanting to be non-biased about this, right? You should be able to provide, evidence of this. It could very well be that she showed these witness statements beforehand, right? Well, if they're referring to Jen, then that can suggest that there's more of there's a lot more of a personal that could be evidence of a personal relationship between the interviewer and the interviewee. That's what she's trying to get at, rather than using her as referring to her as Ms. McCabe, which is a lot more formal and disinterested. and I wish I could find this. These things. There's a.
Went over both of her witness statements yesterday at length. Never once did she say anything.
Okay, so she says she has gone through her witness statements at length. I feel like if you're going to be interested in this as an attorney, I feel like you would want to have allow your audience to have access to these statements or access to the documents that you're referring to. The only reason I haven't done it is because I'm receiving these documents at by the grace of Kate, and I want to reach out to her if I'm going to give permission to post a link to the Dropbox that has all of these documents that I've read. Because I truly believe, like, and I feel like a lot of journalists need to do this too, is that if you're a journalist or if you're an attorney in this case, if you're referring to a matter of public record, whether it be a court case, a court order, or a court opinion, for the love of God, please post the link so that the audience can read what you're talking about and so they can read it for themselves. I hate it when they don't do that.
About going to the waterfall following one of her children's high school basketball games. Never. Anybody else?
How would anybody else do that? How would anybody? Okay. So I wish I could see this. All right, hang on. I should probably look for, okay, where's the file size? Because I thought I saw they don't, Dropbox doesn't allow you to see their file size. I could have sworn I saw in a defense motion that they provide as exhibits. Evidentiary hearing, affidavit in support of Rule 17 motion, Brian Albert's Rule 17 motion. Maybe it's here. There's allegations by the defense saying that the police like modified witness statements or something like that. All right, is this it? No. Memorandum in opposition. I think this is it. Give me 1 second. Motion to inspect the taillight. Motion to inspect this. Motion to inspect that. DNA. Compel discovery. This is Green's testimony. Green's affidavit, I should say. Sorry. Exhibit A. Okay. This is Sir Brian Tully. Interview of Jennifer McCabe. This is okay. So this is probably what she's referring to. This is filed April 6, 2022. This is what I think this is what she's referring to, but this looks like a summary. Of the interview. Okay, I see. Okay, so in this summary dated April 12th, I don't see where they say Jen, but they do refer to Jennifer in the first person, Jennifer McCabe. But they also refer to everybody else in the narrative by their first name. Jennifer, Karen, John, Matthew, Kaylee. Okay. And this is our interview with Brian Albert versus Brian and Nicole. First name basis on a first name. This is Jennifer McCabe, first name basis. This is interview with Matthew McCabe, first name basis. Okay. And this is February 1st, 2022. Ah, here we go. Jen. Okay. So now okay, so here it is. This is the second interview that they did on February 1st, 2022. And then they do refer to, so in this, they spoke with Jennifer McCabe. Ms. McCabe stated in Friday, she and her husband, Matt McCabe. So they shorthand Matthew into Matt McCabe. And then they shorthand Jennifer to Jen. But again, they were, so they shorthand Jen to Jennifer. But they also refer to Karen as in with their first name too in this narrative. And this one with this interview with Ryan Nagel. They refer to him as the first name, Ryan. Okay. So while yes, they do shorthand Jennifer to Jen, in both of these interviews and in all these interviews with the witnesses, they refer to everybody on a first name basis after stating their full name initially.
Now remember, all of these people testified in front of the grand jury.
Okay.
At what point did she all of a sudden mention the high school basketball game? During when she testified in front of the grand jury?
Oh my God. Okay. Oh, I didn't even see it. I didn't even read that. Let's see. Does she reference the basketball game? All right, I don't know. It doesn't look, nope, they don't. Doesn't look like she does. In this one. Mm-hmm. Doesn't look like they do in the second narrative. Again, these are summaries of the interviews. So we don't have a transcript to work off of because these are summaries written by the interviewing officers. Where they were at the waterfall, she arrived at 9 p.m. following one of their children's high school basketball games later in the evening. Okay.
because she did not indicate to Proctor and Buchanan on the day of death that she went to a basketball game. It's not in the statement. We looked at it. I have it. We can pull it up. I've got receipts.
Okay, but does that matter though?
Yeah, what does it matter? Exactly. What does it matter if they were at a basketball game? But why add this new detail into this?
Yeah, I agree. What does it matter whether or not the detail is added?
Why are we adding a new detail into this now? Because it's not
Why?
in the original statement.
Okay.
And they're literally saying this was in the statement. Like, this is what she told them right away. It's not. We have it. We looked at it. At approximately 11 p.m., Mr. O'Keefe and Ms. Reed arrived at the, they don't say Officer O'Keefe, Mr. O'Keefe and Ms. Reed arrived at the waterfall together. Ms. McCabe stated that Mr. O'Keefe and Ms. Reed have been in a dating relationship for approximately 2 years and that Ms. Reed stayed at Mr. O'Keefe's house most nights. Ms. McCabe observed Ms. Reed walk into the bar holding a glass cup from C.F. McCarthy's with a clear liquid inside that she believed was a vodka soda drink. Or, I submit to you, maybe it was seltzer.
Are you now alleging that she wasn't drunk?
If this is even really, accurate.
Oh yeah, by the way, now just realizing it, that I guess the very first statement of the case that, the statement of the case that, Little is comparing this to the very first statement of the case from the outset from October of 2022, it has 2 different authors. I feel like that's kind of important. But maybe is that something to consider? Whether or not one attorney might have additional information compared to the other attorney in their statement of the case. I don't know. And whether or not one is included in the other, I don't know. That bit of information could be significant.
I don't even know. I'm starting to believe that I don't even believe anything anymore. Mr. O'Keefe and Ms. Reed had been at C.F. McCarthy's, a bar across the street from the waterfall, prior to coming to the waterfall. Mrs. McCabe observed Mr. O'Keefe to be wearing a baseball hat, jeans, and sneakers. She stated that the defendant and the victim appeared to be in a good mood and did not observe any arguing between the two throughout the course of the evening. Caitlin. Yeah. Yeah. She further described the atmosphere within the bar as friendly with no arguments amongst any of the patrons. This description of the group and the atmosphere within the bar and between the defendant and the victim was consistent with each of the witnesses present that the troopers interviewed throughout the course of their investigation. So every single person that they interviewed said that they were not fighting or arguing, and they seemed to be getting along great. As the bar began to close, everyone within their group was invited back to 34 Fairview Road, the residence of Ms. McCabe's sister, Nicole Albert, and her husband, Brian. She observed Mr. O'Keefe and Ms. Reed to leave the waterfall together. Notice it also does not say Boston Police Officer Brian. Boston Police Officer Sergeant Detective Brian. Fugitive Task Force Police Officer Boston PD member Brian. No, it doesn't say that anywhere. As Ms. McCabe was arriving at her vehicle, she received a text message from Mr. O'Keefe asking, "Where to?" at 12:14 a.m. Ms. McCabe replied with the address of 34 Fairview Road. At 12:18 a.m., Mr. O'Keefe called Ms. McCabe to ask more specifically where the house was located on Fairview. While inside the residence following her arrival there, Ms. McCabe observed a black SUV consistent with Ms. Reed's vehicle, a 2021 black Lexus SUV, arrive in front of the residence from her vantage point at the front door of the home. Again, she never said that. She never said that in her first 2 statements. In fact, her second statement, which was given 4 days after the incident, she said, "I don't know what kind of car it was because I'm not good with cars." But now it's a black SUV. So did she testify in front of the grand jury? That's all that now she saw a black SUV? We've talked about this before. Eyewitness testimony is some of the most unreliable testimony out there.
I mean,
Anybody ever
I
watch Michael
agree.
TV?
Right. No, I don't deny that.
I also
Sure.
think I need the receipt on this because now this is getting me very curious. 12:14 a.m. I think she said originally that first 12:14 a.m. message was when she was already at the house. But I want to just pull that up for a second and look at it myself. Her first statement actually says, John texted Jennifer at approximately 12:14 a.m. asking where to. So it didn't say where she was, but now she's saying she was in her car. Okay. Oh, and she did in her first statement actually did say she observed a large black SUV. This is on 129:24. But then her second statement the same day to two different officers says she doesn't know what kind of car it was. So the first statement was taken by Proctor, who they're claiming is like a second family to the Alberts and or the McCabe's. And that's why the defense has made a motion to dismiss based on bias. It's very, very interesting because the motion to dismiss the indictment is also under seal. We can't see it because it attaches the grand jury transcripts and all kinds of other things that they don't want the public to have access to at this time because the FBI is currently investigating the investigation. Back to the document. While inside the residence, following her arrival there, Ms. McCabe observed a black SUV consistent with Ms. Reed's vehicle, a 2021 black Lexus SUV, arrive in front of the residence from her vantage point at the front door of the home. Ms. McCabe texted Mr. O'Keefe at 12:31 a.m. stating hello, and again at 12:40 a.m., pull up behind me, referencing her vehicle's parking spot within the driveway to the home, located on the right side of the property if looking at the residence from the street. Ms. McCabe then observed the black SUV move from its initial place where it had stopped on the street near the driveway and proceeded to the left side of the property, where Mr. O'Keefe's body was subsequently discovered later in the morning. At 12:45 a.m., Ms. McCabe texted Mr. O'Keefe again, hello, and then observed the black SUV drive away from the home. Well, the forensics from Karen's phone indicate that she was home by 12:41 a.m. So there's something going on with the timing here. And as you know, because we went over this yesterday, I think it was, with regard to all the forensic evidence that they wanted turned over, many of the text messages and phone calls from Jen McCabe's phone were deleted. And there is battle of the experts going on with the electronics and the forensics and the programs that were used to come to certain conclusions.
True.
At approximately 4:53 a.m., Ms. McCabe stated that she received a phone call from Ms. Reed looking for Mr. O'Keefe. The phone call was placed by the victim's juvenile niece at the defendant's direction to Ms. McCabe's cellular phone. The reason for that is because Karen Reed did not have Jen McCabe's.
All right, I gotta stop here because I can't. We've already gone for 4 hours. I'm not a big fan of this. It's just my problem is like, she has drawn her conclusion, which I guess is fair. She wants to pull, land on the side of the defense. That's fine, I guess. I just wish she'd be a little bit more transparent in when she's referring to documents that, you could give your audience access to them. I want to keep reading. I want to keep reviewing these statements. And these dockets, so I can make sure that I have a lot of what was said, when it was said, committed, so I can bring them back up and take notes. So, but we've been at this for over 4 hours, so I'm gonna stop here. I need to eat something, drink some water. So, I want to thank you guys for watching, and as always, I appreciate you taking the time to hang out with me and as I'm learning about this case. Eventually, I do want to go. After kind of going through this, I'll probably want to switch to like January 6th because I really want to go into that. I want to go into a deeper dive into that. Yeah, you guys have a good one. Take care. Hit that like button on your way out and check out my Discord. All right. Bye-bye.